Okay. Let's work through. Oh, all our defense attorneys are gone. Why are you guys still here?
I wanted to bring some to your attention. So,
is it good news?
I mean, potentially.
For you or for me?
That's up to me.
Okay.
So, I don't know if you recall, Mr. Hall had a immunity motion that was before Your Honor. And
I thought so.
I wanted to see if I could get the transcript of his testimony from Ms. Rivers.
Remind me of the Hall case, is the one where guy goes upstairs with, lady goes upstairs and then guy goes to like, hey, we should leave. And then maybe allegedly showed a gun. And then as he's leaving, pop, pop, pop. And he dies in the breezeway. And there's a female who's sort of an eyewitness. Yes. This is the same Hall?
Yes.
And that's the same case where folks got nutty in the gallery for the bond hearing?
Yes.
Okay, that's what I thought, but I didn't connect. Ms. Rivers is out, so I don't know how that'll work. But we'll see.
Okay.
Let me make a note of that. And in particular, your focus would be his testimony during that. I mean, it'd be great to have everything, but Hall's testimony.
Yes.
Okay. All right. Yes, sir. Mr. Howell, same?
Yes, please.
All right. Ms. Wood, what would you like to do first? And I think I have in my inbox, I'm confused, a motion to get you, oh, it's a different person. Never mind. So do you want to work through Mr. Harris or Mr. Anderson, or do we want to do Mr. Nukem because things are in a position where, boy, we ought to do it while we can? Or do you need to speak with Ms. Clark some
I
first?
need to speak with Ms. Clark. This is, I think the court's familiar. This is a joyride with a golf cart around the park. So I'm hoping that we can do a misdemeanor on this.
Okay. Well, you and Ms. Clark can talk about that. We got all afternoon if we need it. So Ms. Wood, what's the plan with Anderson and Harris?
We could do Anderson first, Judge.
Okay. And is that still a plea?
It's non-negotiable.
Non-negotiated. Great. And Ms. Sims, do you have all the calendars this time? We've equipped you. Excellent. Excellent.
And Judge, I do believe that this is before his final plea date, so I did advise him that
I bet it is.
go our way.
But let's just double confirm. Yes, final plea is right after Thanksgiving. Ms. Clark, are you ready for me to start getting on the record, or do you want a minute?
If I could have a minute.
Sure.
Ready, Your Honor.
Okay. This is position one from our motions calendar. We've got Mr. Anderson out here. Hello, Mr. Anderson.
Hey, how you doing, y'all?
I'm doing okay. Mr. Anderson is here with his lawyer, Ms. Wood. It's indictment 23 SC 188463. We have Ms. Clark for the state. And Mr. Anderson, Ms. Wood has told me that you are interested in entering a non-negotiated plea. And what that means is that I will hear from Ms. Clark about what she thinks the facts of the case are after we confirm you're waiving your rights to a trial, things like that. She'll make a recommendation. Then Ms. Wood will make a recommendation on your behalf. I'll need to figure out what I think the appropriate sentence is. Because this is happening before your final plea deadline, you'll have the ability to withdraw your plea if you feel that the sentence is too severe. If the sentence I impose is more than what Ms. Wood asked for. So just make a simple example. If Ms. Wood says, I think this sentence should be 1 year, Judge. Ms. Clark says 5 years, and I say 4. 4 is more than 1. And so you'd have the ability to talk with Ms. Wood and say, you know what? I'd rather go to trial. 4 years is too much. I think given this case, I might do all right at trial. And so no, thank you. And it's like it never happened. I don't tell the jury, oh, he actually tried to plead guilty or anything like that. But you're also free to keep going forward with the plea, even if I do sentence you to more than what your lawyer has asked for. Does that make sense?
Yes, it does.
All right. After that final plea deadline, which is not for a few weeks, you can always enter a plea. You just don't get to withdraw it if you don't like your sentence, just like with a trial. If you go to trial and you're found guilty, your sentence is your sentence. You don't get to say no thank you to it. But today, you have the ability to say no thank you. In a moment, Ms. Clark will put you under oath. She's going to ask you a bunch of questions. Please let Ms. Wood or me know if any of those questions don't make sense or are confusing you in any way. Will you do that? Great. Ms. Clark.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Could you put your hand down? Please state and spell your true, correct, and legal name.
It's Jairus Enrique Anderson, JAIRUS ENRIQUE
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
38.
What's the highest level of education or the last grade you completed?
Associate's degree.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? Count 1, hijacking a motor vehicle. In the second degree, count 2, aggravated assault, and count 3, battery.
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges.
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review the indictment in this case?
No, I have.
That's it.
Oh. Yes, this is my first time seeing it.
So if you need a chance to look through it, you should certainly take that time, Mr. Anderson. The charges in there are the charges that you and Ms. Wood have been talking about. So there's should be nothing new in there. It all involves an incident that allegedly occurred in October of last year when you allegedly tried to take a Kia from Ms. Lewis. That's what these charges are all about. But if you want to take a moment to read it, I don't want to prevent you from doing that.
I read it.
Okay. Any questions about it, or are you comfortable moving forward?
I'm comfortable moving forward.
All right, Ms. Clark.
Have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes.
Are you satisfied with your attorney's services?
Yes.
Attorney Wood, do you waive a formal reading of the indictment?
We do.
Do you waive any defects in the indictment for purposes of this plea?
So waived.
Defendant Anderson, has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
No,
It's 1 to 12 years, 12 months.
We're gonna go over them anyway.
Can't remember what the max is, Judge.
Carjacking in the second degree, I had to look up because I have never done a second degree one. The range is 1 to 10. So you could be sentenced from 1 to 10 years in custody, or it could be probated or whatever, but the range is 1 to 10. Aggravated assault is 1 to 20, and battery is a misdemeanor. So that's 1 day to 12 months.
okay,
I could sentence you concurrently on those offenses. I could run them consecutively. So the maximum sentence you could receive would be 30 years and 12 months, or as you and I would say, 31 years. The minimum sentence you could get would be probation, where you get out. I don't know how long you've been in, but I'm sure Ms. Wood's going to tell me. Any questions about any of that?
no, I gotta see it right here.
Okay.
One second. Do you understand that your plea today is called a non-negotiated plea,
Yes,
and that the state may recommend a sentence to the court even without your having agreed to it?
yes,
Have you just, do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
yes,
Do you understand that if you enter a non-negotiated plea, you do not have the right to withdraw your plea once the court enters its sentence?
With the exception that because it's before your final plea date, you'll actually be able to do that. Normally, after your final plea date, you can go non-negotiated. Ms. Wood will recommend her number, Ms. Clark will recommend hers, and I'll sentence you, and that's your sentence. But that's not true today. You'll get to hear what my sentence is that I'm giving you, and then you and Ms. Wood can talk about it. And if it's a number higher than what Ms. Wood asked for, then you can think about withdrawing. Now, again, if she says 2 years to serve, and I give you 1 year and 10 months, you may have second thoughts, but you don't get to withdraw your plea because I actually sentenced you at or below what Ms. Wood asked for. Okay?
let me ask you a question.
What's your question? Question about what he just said.
No,
What's your question? Is it about the case?
no,
Okay. You're on the record.
all right,
You want to ask the question?
no, y'all,
Okay, all right. Questions are fine. Ms. Wood is wise saying, hey, ask me first. If it's about something I just said, it's fine to ask it. But sometimes the question may share something that Ms. Wood would prefer you not share until we know the plea is happening.
all right,
But please don't hesitate to ask anything in particular of Ms. Wood if you've got a question. Are you comfortable moving forward?
yes, sir.
All right, Ms. Clark?
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes,
Are you currently on probation or parole?
no,
Do you understand that if you're on probation or on your own probation, you must follow all the special conditions of your probation?
yes,
You understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
yes,
You understand that you are not allowed to possess or use a firearm while on probation?
yes,
Are you a United States citizen?
yes,
Do you understand? Oh, excuse me. Strike that. You understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
correct,
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter the guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
As to indictment number 23 SC 1888463, how do you plead to the charge of hijacking a motor vehicle in the second degree?
Guilty.
How do you plead to the second count, aggravated assault?
Guilty.
And how do you plead to count 3, battery?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
You understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes.
At this time, Your Honor, the state will provide a factual basis for for the felony plea in this case. If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that at approximately 1:15 a.m., APD officers responded to the incident location of 1815 Sidney Marcus Boulevard Northeast in Fulton County, otherwise referred to as the dump, concerning a reported carjacking. Upon arrival, officers could hear the victim screaming for help as she struggled with the defendant over a gun. As officers approached, they observed both the victim and the defendant fighting over a gun in the back of the victim's car. Officers separated them and detained them. This interaction between the defendant and the victim were caught on body camera footage. The car was up against a tree in the middle of the parking lot. According to the victim, she was sleeping in the driver's seat of her car when she was awakened by the defendant banging on the driver's side door and demanding to be let into the car. The victim, Ms. Lewis, declined to let him in, at which point the defendant opened the door and attempted to get in the car. The victim and defendant then got into a physical altercation that spilled out of the car into the parking lot. The defendant overpowered the victim, Ms. Lewis, and re-entered the victim's car and attempted to drive away. The victim, however, grabbed onto the defendant and prevented him from leaving. During the struggle, the defendant began driving the victim's car while still trying to fight the victim off. During the fight, the defendant struck a curb, struck a tree, and backed into a second tree. The victim had a gun in the center console and reached for it. Once she had the gun, the defendant began wrestling for the gun, punching her in the face several times. Officers observed swelling to her face and cuts to her lips. The victim also advised that the defendant bit her several times in the back. Officers observed blood to her pink hoodie. EMS arrived on scene and treated the victim for her injuries. They found an estimated 10 bite marks on her back. Speaking with the victim, Your Honor, it was actually about 14 bite marks. Further investigation revealed the defendant had recently fled the scene of 761 Sidney Marcus, where the Quick Trip is, where he had stolen a roll of duct tape. The duct tape was recovered from his person and returned to Quick Trip. When the defendant was being detained, he claimed the victim jumped on him, armed with a pistol, and he fought her off. He claimed he was the victim of an attempted robbery earlier. The defendant said he knocked on the bitch's window and told her to wake up, and that the bitch pulled a pistol on him. He continued to call her a bitch on scene and told officers she was lying. The defendant said he was just trying to tell her it was too dangerous for her to be sleeping out there. The victim, Ms. Lewis, also had her dog in the car, which she advised ran in fright when the attack happened, and that the defendant kicked the dog. Your Honor, the victim, Ms. Monet Lewis, is on the Zoom call. And speaking with Ms. Lewis, she is actually still suffering both physically and mentally since this has happened to her. She indicated that during the attack, the defendant squeezed her windpipe profusely. And she thought that he was trying to kill her. I actually sent, because I thought this was a bond hearing this morning, sent pictures that the victim provided me on last night. She has several cuts, abrasions all over her body. She indicated that the car that she had was pretty much almost a brand new car, and that she'd only had it for, I think, a little over a year. She says right now that she has $9,000 that she still has to pay on that car, even though the defendant, when he drove the car into a tree, wrecked the car. She's experienced a series of, traumas. She feels like she needs, mental health treatment, but does not have the financial means to pay for it. She believes that the defendant, she did not know the defendant, had never seen the man in her life. She believes that he is a threat to society and that he will do this to someone again. The defendant is a total stranger to her, and all of these things that he did to her were extremely dangerous. Today, Your Honor, unless you want me to wait to tell you what the state is asking. Or you want me to
You can tell me when you want. Ms. Lewis is also on the call, so I don't know if she wants to be heard, if you've talked to her, or if a victim advocate has. I don't want to put her on the spot. I'm happy to hear from Ms. Lewis if there are things she wants to add beyond what you've highlighted in terms of how this has affected her and continues to affect her.
She does want to be heard now.
Okay. Ms. Lewis, are you there?
Yes, I'm here.
Good morning. It's afternoon now. Good afternoon. Thank you for joining us.
Hi, how are you?
I'm doing okay. If you're comfortable, if you want to tell me more about how this situation has affected you and continues to affect you, you're welcome to do so. You don't have to say anything at all, but this is an opportunity for you to be heard beyond what Ms. Clark has already shared. And I'll let you know, I did receive the photographs. I hope, Ms. Wood, you got the photographs as well that were taken at Grady. So I've reviewed that and seen what you looked like after this happened. That doesn't tell me how you felt. My guess is you were incredibly shaken up and continue to be. But if you want to share things with me, I'm happy to listen.
So for the fracture in my face, that fracture is still there, and it will not, it has not healed yet, and I still get pain from that fracture every single day. I still have nightmares from the situation and everything. I have scars that go across my back and my arm that limit because I used to model full time, and I did a lot of headshots and beauty shots, and because of that, I can no longer work. I can no longer work in the industry because of these scars. It's just sad to me to even. I really want to know why. I want to know why. And I have pictures of my car from after the incident as well. He was trying to break into my car. You can see where the window is smashed in, where he was trying to smash the window in. And my car is completely totaled out. Like she said, I have almost $10,000 still to pay on my car. That's another debt that's just accumulating because I don't have the finances to pay for that.
So, Ms. Anderson, I've got a couple questions, if I may. One, did you get your dog back? Your dog wasn't lost?
Yes, I had him microchipped, so I did get him back. He is back.
Good. And how about work? Are you able to work? I understand you may not be working in your industry of choice because of the scars that you've talked about, but have you been able to get back to work? And if so, what kind of work are you doing?
Right now, recently I have not been able to get back to work because it's just been I've been scared to take Ubers. It's anybody that remotely looks like him terrifies me.
Okay. And your car doesn't work anymore? I mean, hitting the tree, I understand it damaged it, but it made it undrivable?
Yeah, so the radiator was busted. It was busted in the front and the back. So there was nothing they could do to fix it. The front was completely smashed in, and then the back of the trunk was completely smashed in as well. So my insurance totaled it out.
Okay. And is that a car that you had leased or purchased, or what was
I had bought it through Carvana, so I guess it's considered a lease. I don't really know I don't know the difference, to be honest. And even just I'm just looking at me and looking at the size of him. I am 5'4" and 105 pounds. If he wanted to take the car, he could have took the car without having to beat me almost to death.
Okay. Well, Ms. Lewis, I appreciate you being here. I know this is not easy to talk about or hear about, and it's only been a year, so it's still pretty close in time and fresh in mind, clearly. I'm sorry for what you went through. Is there anything more, or do you feel like you've covered what you wanted to cover?
I'm okay.
Okay. Well, I know you're not okay, but I appreciate you sharing what you shared. Thank you. Let me get a little bit more information here. Ms. Jackson, good afternoon. Can you share with me what criminal history information you have, if any, on Mr. Anderson?
Good afternoon, Your Honor. He has 12 cycles. The last arrest was September the 30th, 2022 in Barrow County, Georgia for a DUI. There was no disposition for that arrest. He did receive first offender treatment in 2012 out of Lawrence County, Georgia, for possession of marijuana with the intent to distribute. That case was sealed April the 25th, 2020. He does have misdemeanor convictions. This one in 2019 out of Clayton County for Terroristic Threats Act. This one in 2010 out of Loganville, Georgia, for a DUI. Nothing in addition, Your Honor.
Thank you. Ms. Clark, what is the state's recommendation?
Your Honor, the state's recommendation is for count 1, 10 years confinement, for count 2, 15 years to serve 10 in confinement, and for count 3, battery, 12 months confinement. We're asking that these charges be run concurrent, Your Honor.
All right. Any conditions of probation?
Yes, Your Honor. We're asking that the defendant be required to have a mental health evaluation, to complete treatment if recommended. Also, Your Honor, we're asking for no contact with the victim. And also, Your Honor, an anger management course. And if the defendant is determined to have mental health treatment is a recommendation, we're asking for a HIPAA waiver to confirm, so that probation will be able to confirm the treatment. No drugs unless prescribed, and gainful employment.
All right. Thank you.
Oh, Your Honor, sorry. Also restitution to the victim in an amount of $9,000.
All right. So if we're going to do restitution and we would table that for today, you'd need to get some form of documentation from Ms. Lewis showing that it sounds like that's something she could get if it was totaled and insurance is paid out, which we make sure it's not a double recovery, or maybe that money's going to the insurance company, who knows? But certainly we can address that. Let's see if we're actually going forward with the plea today. Ms. Wood.
Thank you, Judge. Mr. Anderson, from the time I received this case, has wanted to accept responsibility. We actually tried to plead this on September 13th. Mr. Peoples was the prosecutor at the time. He needed more time to speak with the victim. The incident stems from a period of time in Mr. Anderson's life where he was struggling with the loss of his mother's death and attempting to learn how to process grief. I do want to just give that context to the court. It is his understanding that the victim was involved with some gentleman who had robbed him earlier in the evening at the MARTA station. He was robbed of his phone, his book bag, and $800. We're not making excuses. I just do want to present that information to the court. He is 38 years old. He's originally from Savannah. He's lived here in Atlanta for 15 years. He has 4 children. He's married. He is an electrician by trade. You heard about his criminal history. He doesn't have a lengthy violent past, Judge. I do believe this is pretty much a one-off. We're asking the court to consider a sentence of 5-1. He's been in custody 381 days on this case. I'm asking for a special condition of a mental health evaluation and a treatment recommended from that evaluation, as well as a stay away from the victim. And I would also request a restitution hearing.
All right. And Mr. Anderson, when you are released, do you go back to Savannah? Are you living in full? Where would home be for you?
McDonough,
And who is in McDonough?
my wife.
All right. I heard you have 4 kids. Are those 4 kids in that household or are they elsewhere?
Nah, I got 3 grown kids and 1 young one.
Okay. And is the young one with your wife in McDonough or somewhere else?
She's with my wife in McDonough.
So you've got a daughter. How old is she?
8.
8. And the other 3 are all adults somewhere else?
They're all adults. They
Okay.
grown.
Are they in Georgia or somewhere else?
They're in Georgia.
Okay. All right. Anything you want to add to this situation?
I just want to apologize to the victim. This never should have happened. Like I said, I was robbed that night. She was with a group of guys who I thought robbed me, and I was just trying to get my belongings back. I just want to offer an apology, a formal apology right now, that this never should have went that far. And I was just trying to get my belongings back.
The apology is important, and I appreciate you doing that. Obviously, it doesn't fix many of the things that Ms. Lewis is working through, but it's important for that to be spoken and for that to be heard. I'm curious, I guess, if you perceived that Ms. Lewis was with these guys who had taken your stuff. I haven't heard anything about, either from what the police observed or from Ms. Lewis's perspective, that it was a 4-on-1 or a 5-on-1, that you were fighting with a bunch of guys and Ms. Lewis. It sounds like you were attacking Ms. Lewis and not someone else. Where did the other guys fit in? If I had a camera and was filming the whole thing, where were they during this?
It was in the vicinity. Like I
Okay.
said, they ran off.
Okay, I didn't hear the ran off part.
No,
Okay.
I didn't say that.
Okay.
They ran off.
Were they in the car?
They were in the vicinity.
In the vicinity. Okay. And you thought, we don't know, you thought they were the ones who had robbed you up at the Quick Trip?
No, I was at the MARTA station.
The Lindbergh MARTA station.
Lindbergh
Okay, so this is
MARTA.
all in the same vicinity.
All this was in the same vicinity.
Okay. All right. And you had taken from you a bunch of money and belongings.
Belongings, my book bag,
Okay.
my phone.
And then you ended up at the QT
Ended up at the QT
and then ultimately in the dump parking lot.
parking lot.
Okay. All right. Ms. Clark, did you have something you wanted to add?
Yes, Your Honor. The victim has, of course, is listening. She sent me text. She said that she does not know who robbed him. She did not have anyone with her that night.
Okay. What I want to do is a back and forth. If there's a trial, we'll do that.
Okay.
Ms. Lewis is the victim here. She doesn't need to defend against anything. And it was helpful to hear from Mr. Anderson. That's why I asked. He said these other people were in the vicinity. He's not saying they were in the car with Ms. Lewis and they jumped out when he approached. And it may well be that night, Mr. Anderson, after what you went through, you weren't thinking in the right way, because what you did to Ms. Lewis isn't something that should happen to Ms. Lewis. And you've apologized. And like I said, that's important to hear. I want to make sure, and Ms. Lewis has already said this, that it doesn't happen again to anyone else. You've seen and heard the impact that it had on Ms. Lewis. Here we are a year and a couple of weeks later, and it's difficult for her to talk about it. I've seen the pictures of how she looked there in the emergency room right after, and for her to say their scars make sense. And I had no idea that she's someone who, for part of her career, was a model, and now she's saying that's not a possibility. So there's a lasting impact of the decisions you made, and they were ones that terrified her. And I guess we should all be grateful that that gun didn't go off, because you could be dead, she could be dead, you both could be dead. I mean, that's how serious it got. She was scared enough that she was reaching for that, and Fortunately, the police arrived in time so that it didn't get worse than this already very bad situation. Mr. Anderson, I find that there's a factual basis for your plea. That doesn't mean I'm saying if you go to trial, the jury's going to convict you. But I do think that if the jury heard the kinds of things Ms. Clark has talked about, sees the pictures that they'd get to see, here's testimony from Ms. Lewis, that they could find you guilty. So I'm going to accept your plea. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we've talked about. Do you have any questions about anything we've discussed so far?
No, Your Honor.
Voluntary means no one's forcing you to enter this plea, but you've decided that you want to try out this plea, knowing that you can withdraw it if the sentence I impose is more severe than you're willing to handle right now, and you'd rather have this case go to trial. I'm sentencing you pursuant to the Probation Options Management Act. That means that the portion of your sentence that's on probation, while you're on probation, if you have what we call a technical violation, you miss a meeting, or, and I'm making this up, I'm not suggesting this is your lifestyle, you test positive for marijuana or something like that, you don't have to come back and see me. You and probation will work through whatever the consequences ought to be for that. But if it's more serious, you get arrested for something, or there's any evidence that you have attempted to contact Ms. Lewis in any way, calling her, writing her, anything like that, that will come back to me and we would deal with the consequences of that. Ms. Lewis has described you as a complete stranger. Would you describe her in the same way? As in, this is not someone you knew prior to the evening of October 23rd?
I didn't know her.
Okay, that's all. I asked that in a weird way, but you didn't know her before that night.
I didn't know her.
That makes the no contact all the easier. It's not someone you've known before, like, oh, I got a set of friends and she's got a set of friends and they're going to overlap. It ought to be real easy for you to never, ever be around her again. You agree?
Yeah, that's correct.
Okay, especially if you're going to be down in McDonough. All right. Mr. Anderson, I am recommending right now, not having heard all the evidence at the trial, but what I've heard and seen today, a sentence of, and I'll break it down in pieces in a minute, of 8 years to serve 3 years with the balance on probation. So count 1 would be 8 to serve 3, count 2 would be 8 to serve 3, and 3 would be serve all 12 months. I've already served those. They'd all run concurrently with each other. You get credit for the time you've been in. The special conditions of probation would be number 1, most important, no contact with Ms. Lewis. Number 2 would be that you do submit to a mental health evaluation, just so we can make sure if you're working through grief issues or anything else, that a subject matter expert, a doctor or a counselor can say, you know what, Mr. Anderson, you will be safer and the people around you will be safer if you get some counseling or you take medication, whatever the experts say. If they recommend some form of treatment, that treatment becomes part of your probation. You'll need to take an anger management course. And I'm going to table the question of restitution for 2 reasons. 1, the state needs to prove it up. But 2, I don't even know if you're going to go forward with your plea or not. So I want you and Ms. Wood to talk about it. Clearly, my sentence is more severe than what Ms. Wood asked for. It is 2 years longer, and it's 1 in terms of custody and 1 year more of probation. It's less than what the state asked for. I understand what the state asked for as well. I think this is important for Ms. Lewis to hear. You can hear it as well. I deal with aggravated assaults of all types and natures. And what happened to Ms. Lewis is inexcusable and it's terrifying to her. But you being in jail for 7 years longer than what I imposed isn't going to make her any safer, because I don't think you're ever going to be around her again. It is going to incapacitate you for more years than I think is necessary and takes you out of a situation you ought to get back to if it's safe and healthy for you to get back to, which would be to be with your family. And 3 years is not a light sentence. I bet you could tell some stories that would be just as traumatic about what the last year has been like at Rice Street. And I'm mindful of that, and that's part of your sentence. But I think that 3 years is sufficient punishment and deterrence, that right now I find that to be a reasonable sentence. 2 more things. 1, that's not necessarily your sentence if you go to trial and you're found guilty. Ms. Wood would be able to say, hey, judge, you thought that 8 serve 3 was reasonable back in the day. But I could hear more. We would have live testimony from Ms. Lewis. She would have to relive it all. I might learn more about the scope of her injuries, et cetera. So I don't want you to think that you know what would happen if you go to trial and you're found guilty. It would not be a vindictive sentence on my part to sentence you to more after trial is over. Second thing, you and Ms. Wood should talk, because this isn't what you asked for through your lawyer. And so I stand by what I said at the beginning, which is you can withdraw your plea if you think that going to trial would be a better situation for you. And so you know, you will be on our January 10th trial calendar. So trial is not a distant, when would this happen? I would see you again for your final plea, which would be after Thanksgiving, where we would basically repeat this, and I don't know what would have changed by then. And then in early January is the trial count. Just wanted you to have all that information. You two should talk.
Thank you, Judge.
Okay. Hi, Ms. Willingham. How's things? All right. Ms. Wood said that the Harris matter might be a plea also.
Yes, and I sent the terms to Ms. Nelson because we also accused of an indicted case.
That's what I heard.
A new case number.
Great. Thank you. Ms. Feely, have you and Ms. Clark had a chance to talk about Mr. Nukem?
No.
I guess you can do that while we're taking the Harris plea, because whatever's left for Mr. Anderson will be quick. It'll be no thank you or yes. Let me see, Ms. Tucson, do you need to share anything with Mr. Anderson, or because it's a 3-year custodial sentence, he would deal with his probation reporting information when he is approaching release?
That's correct, Judge. And Miss Wood, she did send me an email.
Okay, great. Then no. Ms. Wood, you are relaying that Mr. Anderson wants to move forward with the plea. What that leaves is restitution, and I will leave that to Ms. Clark and Ms. Wood. It may well be, Ms. Clark, that the documentation that you get from Ms. Lewis is sufficient for Ms. Wood to say, we don't need a hearing based on this. is $9,000. If we need a hearing, we'll do it. And we may have Mr. Anderson zoom in if he's already been transported to the Department of Corrections. But I'm going to leave that up to you, Ms. Clark, to reach out to Ms. Nelson to schedule the restitution hearing after you've had a chance to review the type of documentation Ms. Lewis has for the damage to her car. Okay. Ms. Lewis, I want to thank you.
Whenever Ms. Clark does get that, if she could forward it to me so I could give it to the accounting team for probation. That way, whenever that does start, the payments will go right over.
I'll be sure to have her get that to you if I impose restitution, but we need to make sure that the paperwork is sufficient and of course, give the defense a chance to contest it if that's what they want to do.
Okay, no problem. Thank you.
Great. Okay. Ms. Lewis, I'm sorry. I was saying one last thing to you. I wanted to thank you for taking time today to be present for what was going to be a bond hearing, but also to share your experience through this. And I wish you the best going forward. This is only another step in your journey of recovery, but your voice was heard. And Mr. Anderson is going to be out of commission for a while now. And more importantly, has a condition for the remainder of his sentence to have no contact with you at all. So I wish you the best as you move forward.
Thank you.
You're very welcome. All right. Thank you, Ms. Clark. I think what we're ready for now is to handle, if you're ready, Ms. Wood, you're going back to back now. Ms. Willingham said while you were talking with Mr. Anderson that she's for, I got the email now. There's an accusation, so we're doing a global plea to 2 cases, et cetera. Do you need to speak with Mr. Harris or you're good?
I just need to show them the breakdown, but it doesn't change anything. So
Okay. All right. Ma'am, are you here for one of the 3 cases? Okay. Ms. Willingham, is this a negotiated plea?
Yes, Judge, it is. Judge, I brought candy for the courtroom that I really don't want to take back to my office because I will eat it. Can I leave it over here?
You can, and we'll restock. You can see everyone is offloading it to the courtroom. A lot will get eaten tomorrow with the trial calendar.
Yes, in fact, I actually have 2 more bags for us and this is my house.
So someone overbought, huh?
Well, they told us to bring 2 bags per attorney for our trick or treating within office.
Oh, it was an office one.
But then everybody left early, so
Oh,
nobody trick or treated.
well, boo. Okay. All right, are you ready to go? I don't think, do you have anything on the trial calendar? We went through the whole trial calendar call.
I do not.
Holy smokes.
I actually don't have anything this month or December, but
Well-
that's okay because I'm specially set in 2 courtrooms.
Okay,
for
maybe
murder.
that's
So-
why Miss Nelson was looking out for you. Okay, Mr. Harris, I'm sorry to keep you standing right there. Let's go on the record with position 2 on our motions calendar. It's 23 SC 188531. Londell Harris, who's represented by Ms. Wood, who's standing by his side. Ms. Willingham is the prosecutor. And we are also taking a plea in a brand new accusation, which is 23 SC 190750. And we'll get more information about that from Ms. Willingham on the record. But my understanding, Mr. Harris, is you're prepared to go forward with what we call a negotiated plea, which means both sides are recommending the same thing. That doesn't bind me, but if I sentence you to more than what they asked for, you can always withdraw your plea. Okay?
Yes, sir.
Understand that?
Yes, sir.
All right. Then Ms. Willingham's going to put you under oath. You'll be answering a bunch of questions from her, a few from me. It's important that you let Ms. Wood or me know if you've got any questions. Will you do that?
Yes, sir.
All right, Ms. Willingham?
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matters currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name, your age, and your date of birth.
Man, Londell Maurice Harris, 45 years old, and my birthday is 6/17/1978.
You can put your hand down, sir. Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
I got a GED.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the documents that charge you in these cases?
Yes, I just looked over 'em. I looked over 'em.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights: the right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case, or in case ending in 8531, count 1, false imprisonment with a minimum of 1 year and a maximum of 10 years, you would be sentenced to 5 years probation. Count 2, false imprisonment would be non-pressed. Count 3, aggravated stalking with a minimum of 1 year and a maximum of 10 years, you would be pleading. And you would be sentenced to 5 years probation.
Yes, ma'am.
Count 4, battery family violence, and count 5, cruelty to children in the 3rd degree. Both of those counts would be non-pressed. In indictment ending in 90750, count 1, false imprisonment, 1 year to 10 years. You would be sentenced to 5 years probation. Count 2, criminal damage second, which has a minimum of 1 year, maximum of 5 years. You would be sentenced to 5 years probation. Count 3, battery family violence with a minimum of 1 day and a maximum of 12 months. You would be sentenced to 12 months probation. Count 4, cruelty to children in the 3rd degree with a minimum of 1 day and a maximum of 12 months. You would be sentenced to 12 months. All counts would run concurrent. And both cases would run concurrent. You would also be required to have no violent contact with the victim. And I'm sorry, Judge, I want to click back over to the special conditions.
I've got no violent contact, family violence intervention, 60 hours community service.
Thank you. Is this what was explained to you by your attorney?
Yes, ma'am. Another thing I want to ask you that I know you.
We'll talk about that
Okay.
later. We're good.
Yes, we're good.
We're good?
Yes.
Okay.
Are you now serving any other sentence? I'm sorry, before I go there, do you understand you are not required to plead guilty to charges unless the grand jury has heard sworn testimony and charged you in an indictment?
Yes, ma'am.
Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
I'm on probation, Cobb County.
Do you understand by pleading guilty today that your probation or parole may be revoked?
Yes, ma'am.
You heard me tell the court what the negotiation is in this case, which is 5 years probation. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law?
Yes, ma'am.
Do you understand, however, that if the court does not accept this negotiation, you have a right to withdraw your guilty plea today?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you will be required to follow the special conditions of probation previously discussed. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which cause you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I've asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, yes,
Is your decision to plead guilty made freely and voluntarily?
yes, ma'am.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You will have 4 years from the date the sentence is entered for the felony offenses, and you will have 12 months from the date the sentence is entered for the misdemeanor offenses. Do you understand these time limits?
Yes, I do, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, I do, ma'am.
Your Honor, as to indictment ending in 8531, if this case were to proceed to trial, the state would prove beyond a reasonable doubt that on July 7th, 2023, the defendant and Miss Morgan, and first name Heather Morgan, were in an intimate relationship and lived together at the time of the incident. Harris and Morgan had been verbally arguing about their relationship for approximately 2 days. On July 7th, 2023, as the argument escalated, Morgan decided to leave the location with her juvenile child, Chrisette. However, Harris refused to let them both leave. When they tried, Harris physically abused Morgan by striking her with his fist. Harris refused to let Morgan and their minor child leave for approximately 12 hours. Every time they would try and leave, Harris would strike Morgan or threaten her. Eventually, the child worked up the courage to call 911. When officers arrived, they observed bruises on Morgan's arms. Morgan was crying and visibly shaken up. Harris was arrested on scene. On July 8th, 2023, Harris received a bond subject to the special conditions that he had no future contact with Morgan. Harris called Morgan from jail several times the same day. At 11:06 p.m., Morgan answered the phone and said, "Stop calling me," to Harris. Harris then called Morgan over 60 times. Morgan did not answer any of the phone calls. 2 days later, as Harris continued to call, Morgan answered the phone and screamed, "Stop calling me," several times. Harris continued to call Morgan in violation of his bond order. Your Honor, as to accusation ending in 90750, as to the false imprisonment count on October 20th of 2020, well, between October 20th, 2023 and October 21st, 2023, said accused in violation of personal liberty of Heather Morgan detained her without legal authority. By pinning the victim down in the bedroom, which restricted Miss Morgan's movements. Also, Your Honor, the defendant did intentionally damage the property of Heather Morgan, a Samsung Galaxy S23 Plus, without Miss Morgan's consent by banging the phone against the dresser, which caused damage to the screen, that damage exceeding $500. While the victim was pinned down to the bed, she also sustained small cuts to her right wrist and the back of her left hand. And at the time, the minor child, C. Morgan, was present and could hear the altercation. I have had an opportunity, Your Honor, to speak with Miss Morgan, and I don't know if Your Honor recalls, but this is the case where we were previously set for, I believe, plea and arraignment. And the defendant appeared, and as I was speaking, saying that the state had not been able to reach the victim, it was pointed out that they were actually sitting together and had come into the courtroom together.
So this would have been arraignment on the first case.
Correct.
And then Mr. Harris managed to get arrested again in similar circumstances.
Correct, Your Honor. And when I spoke with Ms. Morgan earlier not earlier this week, towards the end of last week, because obviously we were already coming up for a motion to amend the bond, as it was brought up in court last time that they were living together and that they wanted to amend the bond so defendant could be around her. Ms. Morgan stated that she does not wish to proceed. I think that the case that was already currently before the court, based on the evidence that we have and based on the defendant's criminal history and the incidents between the two victims, I think that that case was completely solid. I do think the case that we have recently accused, the state could prove, but I think that considering Miss Morgan and the minor child are the only two victims or the only two people that were present, I do believe we would have just a little bit more of a complicated situation. So based on that, the state had already previously extended the 5-year probation offer. And as a way to resolve both cases, we thought that it would be fair at this time to do a global resolution to both cases. And Ms. Morgan does not, for the record, again, Ms. Morgan does not believe that the state should proceed on either case, despite her being the listed victim in both of these cases, as well as, I believe, a case out of Cobb County. I know that case was going before the court when we were last here. I'm not sure what the ultimate resolution was on that case. And that concludes the state's portion.
All right. How old is the child? And if you know Mr. Harris, you can.
She's 8 years old. She's like a daughter to me. Yeah.
Okay. 8. All right. And are you seeking restitution for the damage to the cell phone?
No.
Okay. Fun. Ms. Jackson, criminal history information for Mr. Harris, please.
Yes, Your Honor. He has 34 cycles. The last arrest was July the 7th, 2023 in Fulton County for cruelty to children in the 3rd degree and false imprisonment and battery family violence. That case appeared to be still pending. The case number is 23 SC 188531, and it's for 2 counts of false imprisonment and aggravated stalking and battery family violence and cruelty to children in the 3rd degree. He appears to have an open case pending in Cobb County for battery. And also he has an outstanding hold out of Marietta, Georgia for a probation violation. The date on that warrant is September 21st, 2023. And he does appear to be on probation in Cobb County for robbery. That disposition date was June the 24th, 2016. 3 years of confinement and 7 years of probation. And he has prior felony convictions. One in 2016 out of Cobb County for possession of cocaine. One in 2012 out of Cobb County for possession of marijuana with the intent to distribute. One in 2006 for possession of controlled substance. One in 2003 out of Douglas County for 2 counts of possession of controlled substance and the use of communications facility in a drug transaction. And he does have misdemeanor convictions. One in 2002 out of Carroll County for obstruction of an officer. One in 2000 for disorderly conduct. He does appear to have a history of probation violations. It's one in 2023, one in 2020, and one in 2018. Nothing in addition, Your Honor.
Thank you. Ms. Tucson, you're showing Mr. Harris as being on probation out of Cobb?
That's correct, Judge.
Okay, thank you. Ms. Wood.
Thank you, Judge. We would just ask that you accept the state's recommendation. I and my investigator have both spoken to Ms. Morgan numerous times. She has shared that she does not want this to proceed with me as well as Ms. Willingham, as you heard. She also shared with us that she believes that her drinking issues played a part, that Mr. Harris was trying to prevent her from drinking and driving in at least one of the cases. So I did just want to put that out there for the court. Otherwise, we would ask that you accept the state's recommendation.
Mr. Harris, anything you want to add?
Yeah, Ms. Lacey Wood, she's telling you that Miss Heather Morgan, you know, I love her to death, and we live together, we have a home together. She said she's like a daughter to me, you know what I'm saying? I always tell her that we don't need to be arguing around, you know what I'm saying? But like she said, Heather Morgan, she gets up in the morning and she drinks, you know what I mean, like coffee, you know what I mean? So it's hard to deal with that. And then, but me being a male, her being a female, it was always pointed at me. And another thing, I never punched her. Never. She had bruise on her arm. That didn't come from no punch. You know what I'm saying? So I would never put my hand on no female like that, man. You know what I mean? She has a real reckless mouth, like I say, and it's a lot of things that she done that I've never said nothing. I've never called the police and nothing, you know what I mean? Because she's a lady and I'm a man.
So why do you stay together? It sounds kind of tumultuous and it's getting you in trouble.
Yeah, well, we talked about it and I'm gonna get, I take medication, Abilify. And I'm gonna get some more. I've been taking my medication for like the last month, but I'm gonna get psychologically help. And me and her gonna go to counseling together because we really care about each other. And we're trying to make this work.
What does Abilify help with?
Manic depression and anxiety.
Okay. Are you taking it now in custody?
I'm trying to get them to give it to me now. They said they got to get in touch with Viewpoint in Gwinnett County before they can do it.
You haven't been in very long, so I can see why they may not have plugged you into the medication. Were you taking it before you got locked up?
I hadn't took it for like a month before I got locked up. I just made an appointment to go to North Spring. We live in Sandy Spring, go to North Springs Medical Center, Health Center to get a new prescription. And I got incarcerated.
When you get out, is the plan to move back in with Ms. Morgan or to stay somewhere else, but maybe have Ms. Morgan in your life?
Well, she has 5 DUIs. So she had to turn herself in at the end of November. She's been fighting for 2 years. And so she'll be incarcerated for like probably about 2 months. But I am gonna go to the house, to our house, and I'll probably take care of Cassette, help her go to school and stuff. You know what I mean? Because really, she ain't got nobody else. She's just off her mother. Doesn't really have any family.
Okay.
So she's incarcerated. I would be at the house.
Okay. And in the house would be her daughter. Are there other people in the house?
Just me and Cassette.
Okay.
I would be taking her to school in the morning and going to work and coming back from work and picking her up from the bus stop.
And what's work?
Well, I'm trying to get back with a company called C.W. Matthews, it's an asphalt company. But until then, I'll be working through temp agencies.
Okay, so there's not a job specifically waiting for you. You're hoping to connect with something else.
I'm in with Randstad, so all I gotta do is get out and call them so they can send me wherever they want me to go to.
Okay.
So I can keep the bills paid.
Got it. Last question about this situation, then I just need to cover some basic stuff and we'll move forward. Was it not a condition of your bond in the older, neither case is very old, but I'm gonna call it the July case. Wasn't it a condition of your bond in the July case that you were supposed to stay away from Ms. Morgan?
Yes, it was a condition, but I had nowhere else to go. You know what I'm saying? That was my home. The lease is in my name and we were trying to work it out, and DFAT was trying to put us in counseling.
Okay.
But it was a condition though, sir, and I never planned on none of this to happen. Like I say, it's just hard to explain, man. You had to be in that household to see what was going on.
No, I don't want to be in that household.
Yeah.
I believe you. And there are always two sides to the story. And I'll tell you, I've learned in doing this work and working with prosecutors and defense attorneys who work through it, in many of the domestic violence situations, it's not as black and white as mean man hit innocent woman, but that people are jawing at each other and then someone swings and someone else swings, and it's almost like a schoolyard fight where everyone's in trouble. But in the end, the police have to arrest someone, and that's the person who gets the label of the primary aggressor. I wasn't there. I don't know exactly what happened. I do know you've been arrested a whole bunch of times. You're a grown man, and you're going to need to come up with a different way of processing this. And you may need to take some deep introspective thoughts about whether it is safe and healthy for you to be around Heather Morgan. And that may be an emotionally difficult decision to make, but you know what the default is going to be. If someone calls 911 and they show up at that household and she's crying and she's got a bruise, who's getting locked up? You. Doesn't matter who starts it. Doesn't matter if she's been drinking. You get locked up. And maybe you should be, because maybe you hit her first. Like I said, I wasn't there, but you got to start processing how this is in and up for you. In Cobb, they may be a little less flexible than we are. I don't know what's going to happen with your Cobb probation. That may make what's going on here seem like a cakewalk. So you just need to think long and hard about what is best for you, and also for little Chrisette, because you say you treat her like a daughter. Her being around you guys doing what you're doing is messing her up. She is seeing the people who she sees as mom and maybe dad, stepdad, whatever she calls you, Uncle Harris. She needs to not see that happen. That is not good for her, and you need to own that. All right, enough of my sermon. I find there's a factual basis, Mr. Harris, for your plea in both cases, and that your plea is knowing and voluntary. Knowing means you've understood all the things we've talked about. Voluntary means no one has forced you to enter these pleas. Do you agree with that?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a minor violation, that'll go to probation. But if it's major, you get arrested again, or there's any suggestion that you and Ms. Morgan got into it again, that comes back to me. And I'll just tell you up front, it won't be measured in months next time. It'll be, you know what, this so much didn't work out. I'm more worried about Chrisette. I'm going to protect her. You're out of commission for a year. And when you get out, you can't be around either of them. So this is your last chance to be around them some, although I'm going to modify the recommendation a little bit. So hear me out. Ms. Clark, do you authorize my staff to sign the accusation and the indictment on your behalf? I'm sorry, is it Ms. Clark's over there? Ms. Willingham, I know the difference. We just did that plea. Ms. Willingham.
Yes, Judge.
Okay, all right. And Ms. Wood.
Yes, Judge.
All right, Mr. Harris, is it okay if someone on my staff puts an electronic signature of yours indicating guilty pleas in the two cases?
Yes, okay.
Okay, I mean, not normally, long time ago, you'd sign the piece of paper in front of the indictment, but my staff does that in the back office. You all right with that?
Yes, sir. So are we going with the probation?
I'm not done yet.
Okay.
Hear me out. All right. So my sentence for you in 23 SC 188531 on count 1 is 5 years to serve 2 months with the balance probated. Count 2 is dismissed. Count 3 is 5 years to serve 2 months with the balance probated. Counts 4 and 5 are dismissed. In the new accusation, you've pled to all 4 counts, and your sentence on counts 1 and 2 are 5 years to serve 2 months. 3 and 4 are 2 months to serve. They'll all run concurrently with each other, and everything runs concurrently, so all at the same time. Special condition of probation number 1, and this applies to both cases. No violent contact with Heather Morgan. That'd be a crime anyway, so in some ways that's not a condition. But because I've made it a special condition, if we're together again in 3 months and there is a picture of Ms. Morgan and there's a bruise on her face, and her testimony is, and I find it to be credible, I don't know that I will, but if I did, that you put it there, I could revoke all your probation. Not a month, not half of it, but all of it. Special condition number 2 is that you will complete the family violence intervention program. Number 3 is that you complete 60 hours of community service. Number 4 is that you submit to a mental health evaluation. And that's just to make sure another doctor talks to you soon. And if that doctor says you should take Abilify or whatever else it is, that treatment is a condition of your probation. And finally, special condition number 4, whatever we're on, for the first 6 months of your probation, you and Ms. Morgan cannot live in the same household. You can spend time with her, you can be around Chrisette, but you guys cannot be in the same household. If she has 5 DUIs, she's got her own things she's working through. She's going to need to figure that out. So you don't need to stay apart, but you can't live in the same household. When probation knocks on the door to see how things are doing, if it's 4 a.m, Heather Morgan better not be there. She needs to be somewhere else. So you can spend time together and you can be with Chrisette. But we're going to spend a few months with you guys in different places to see if after those 6 months, you think it still makes sense for you to be in the same household. Okay. I am adding a little time to serve because I want it to sink in how serious this has gotten, whether it's because of her drinking or yours, or you're not taking your meds, or whatever the explanation is, because like I said, I wasn't there. It's reached the point where we've got a 45-year-old man who's been arrested 34 times. And more recently, it seems to all flow out of the dysfunction of this relationship. And so you're going to miss Thanksgiving with your family, whether that means being with your mom or other folks. And that's for a purpose. So you're thinking about, what do I want to do now? I'm all grown up. I can work and I can care for myself. How do I care for myself consistent with being around Heather Morgan? And I don't know the answer to that, but you need to think about it. Okay.
Sure.
So that sentence is a little more severe than what Ms. Wood had asked for. So if you want to withdraw your plea, you can. You're not going to get out of jail until we work this out. So you can do the math as to when I'd see you again. But I want to recognize that it's not you get out tomorrow. You probably won't do the full 2 months. You'll get credit for the 18 days. And so you may get out before then. The most you'd be in would be for 2 months minus 18 days because you've already done the 18 days.
Okay.
Do you want to talk with Ms. Wood, or do you know you're going forward with it?
I'm gonna go forward with it.
Okay. The last thing we need to do then, Ms. Tucson, do you need to give Mr. Harris any reporting instructions? Because he will get out pretty soon.
Judge, if I may interject.
Yes.
He does have the hold.
What is the Marietta hold anyway?
Yes, he does have
Okay.
Cobb County hold, so I'm not sure how soon he will get out.
Okay, well, fair point. And I wrote that down. If for some reason Marietta grabs you tomorrow and says, hey, we don't need you anymore, you still have that 2-month window. But that clock is running the whole time. Even if you go up to Cobb to deal with whatever your business is up there, those 2 months are running. Okay, so I hadn't really thought that through. You're missing Thanksgiving, whether it was me or Cobb County. Ms. Tucson, do you need to get any information from Mr. Harris, or is he plugged into the system through Cobb? She's not plugging in with us right now. Ms. Wood, I assume you've got contact information for Mr. Harris. He's been in and out, so you can pass that on if
I will
need
do
be.
that, Judge.
Okay.
Thank you.
All right. Thank you. Thank you, Ms. Willingham. Ms. Feely, my thought is that we call the final plea calendar, unless if we don't do Mr. Nukem right away, that could be problematic.
I think he's fine for today.
Okay. Is it going to be a plea?
That's my hope.
Okay. Well, let's keep talking.
Sure.
All right. We've got a final plea calendar. We're not that late for 1 o'clock. For those of you, do we have folks in custody for this, or it's all on bond? 2 in custody? Okay. For those of you not in custody who have a case on here, do know that while today is final plea, which is the last day you could enter a plea and withdraw that plea if the sentence you get is more severe than your lawyer asked for. If we don't resolve your case today, you are all on the December 1 trial calendar. So I will see you all again, if we don't resolve your case today, on December 1st, when we call the trial calendar, and we will try your case either the first full week of December, or the second. So everything's getting all bunched up here at the end of the year. All right, positions 1 through 3 are Robert Daniels. He's in custody. Ms. Wood, have you received, this is a gentleman who was in drug court. I remember Mr. Daniels. Sometimes he has family here, but you got all the discovery in Mr. Daniels' case?
Yes, Judge, and this is the one we attempted to resolve previously.
Oh, and there was a no thank you then, I think. Okay.
I'm assuming the offer is the same from the state, and this will just be a final year.
Okay. Got it. So we'll get that offer we'll bring him out and get that on the record in just a minute. Okay. Michael Reynolds. Hey, Mr. Reynolds. I am okay. Your lawyer, I think, does he have a conflict, Ms. Nelson?
Yes.
Pardon me?
He called me yesterday, he said he took a legal leave.
Yeah, I got word of that. I don't know what the leave is, but he can't be here. And so all I did, Ms. McCauley, is preserve Mr. Reynolds' final plea rights so we don't delay this at all and move it to wherever it was going.
Fine, Judge. I think it should be filed now. I filed a lack of fry notice with the state's offer. It's been communicated to Mr. Shepard. I'm sure he'll have a conversation with his client. I think it's supposed to be moved to the next trial calendar. The state would still be asking for that December 4th start date.
Okay.
I know that there's another case that's competing for that date, but
Right. We'll know more about that tomorrow afternoon, but that continues to bedevil Mr. Abate.
it does, and I think Mr. Shopper at the motions hearing had indicated he has some scheduling issues in January.
Okay, right. And so December 4 is your preference.
Absolutely our preference.
Okay, all right. Mr. Reynolds, we're not going to talk anything substantive about your case because Mr. Shepherd's not here, but it's important you understand that I will see you on December 1st when we call the trial calendar, and then we'll figure out of the cases on that trial calendar, which do we try the first week and which do we try the second. Ms. McCauley is asking that yours go first that first week. Given the age of the case, I'd be inclined to do just that if I don't have a conflict with an actual even older case that is lurking around out there. Do you have any questions about anything I just said? Okay, so you'll need to be back here December 1. Well, before then, you and Mr. Shepherd will be talking. Ms. McCauley, I think I've ruled on all of the pending motions except for the residual hearsay. Is that your understanding?
That's my understanding, Judge. I've received the court's order from the other motions, and the residual hearsay is the only motion that's outstanding.
Okay, great. All right. Mr. Reynolds, you are free to go. And I'll see you on December 1. And Ms. McCauley, if that was your only case, thank you for being here.
Okay, thank you, John.
You bet. Travis Flint. Ms. Willingham, you done? Take care. You left it right here, huh? All right, got it. Thank you. It's all Twizzlers. That's junk. Okay. All right. Sounds good. Ms. Nelson, had you heard anything from Mr. Luemba?
Yes, he's joining the call in just a minute, Judge.
He said what?
I'm sorry, Judge. He's joining the call in just a minute. The Zoom.
Okay, great. Maybe he'll have his client with him. Ms. Clark, have you had any success talking with Mr. Luemba about these cases?
No, Your Honor, but I have sent an offer.
Okay, so at least via email, he received an offer.
Correct, Your Honor.
All right, most of all, we'll need Mr. Flint. Okay, let's see what else we have here. Andre Williams.
It's my case, Your Honor, and I just got a new offer I need to relay to him. If I may have an opportunity to do that. It should be a plea today.
So, Mr. Williams, I'm going to finish calling the calendar. Ms. Feely will talk to you. Sounds like whatever the offer was got a little better. So you and Ms. Feely talk about that. Ms. Marsh is here as the prosecutor, and maybe we'll sort it out today. So please don't go anywhere till I say it's okay to go, but it may be we're resolving your case today. Desiree Hollman. Hello, Ms. Hollman.
Similar situation. I've been speaking with Mr. Jordan about this case. We're continuing those discussions, but we're hopeful to resolve today.
Okay. Are you the stunt double for Mr. Jordan?
I am, because he's in trial on 1T.
That wouldn't work well in a movie, but okay.
Yeah, I'm in trial, or he's in trial on 1T.
Oh, he has the Judge Swall case.
Yes, him and the dynamic duo of 88 Atkins and 88 Jordan.
All right.
Round 2. Actually, I think this is round 3.
Okay.
Either way, I'm happy to speak with Ms. Feely and see if we can try to get that case resolved today.
Great. Let's do that. Ms. Holloman is here. Are you Travis Flint?
Yes, sir.
All right. Made it just in time. We're waiting for your lawyer, so sit tight. So Ms. Holloman, Ms. Feely is going to come talk to you, and then maybe we resolve your case today. Please don't leave till we talk one more time, okay? Thank you. Alexis Strodder. I think this is the person from Florida, based on who the defense attorney is. Is that right, Ms. Nelson?
Judge, I'm not sure Mr. Strodder is representing him. Let me see if I can track him down.
Okay, let me look this case up real quickly. No, this person, it says Centennial Olympic Park. All right, but no Alexis Strodder. All right, coming back. Samuel Bryant. Mr. Bryant is here. Ms. Wood, is this your case, Ms. Clark?
Yes, Your Honor, it is.
All right, Ms. Wood.
Judge Kenneth Muhammad entered an appearance on October the 28th for this case.
Okay. I don't know when this calendar was published, but my guess is that's going to be an issue. All right, Mr. Bryant, you hired Mr. Muhammad? All right. When we take a break, can you try calling him?
I spoke to him already, so he was on my.
Okay, well, how it's gonna work is he'll pop, like Mr. Brown just popped on. Lawyers pop on all the time. I don't see him yet, but he'll make it. I hope so. If not, I'll have you call him and say, get on a Zoom. But if you'll sit tight. Thank you. And I'm assuming Ms. Clark, well, I don't know, have you interacted with Mr. Muhammad or always Ms. Wood?
I interacted with Ms. Wood, but Ms. Wood informed me yesterday that Mr. Muhammad had signed an entry, so I did submit the offer
Okay.
that I had to him.
Okay, great. Number 11 is Mr. Salmeron-Abara. He's in custody, and we have Mr. Brown on the phone or on the Zoom. We have Mr. Shapiro here. We'll need to get an interpreter online or in court, I guess, just to walk through what the final offer is so we can move this forward. Are you ready for that?
Yes, sir.
Okay. Mr. Brown, good afternoon. How are you?
I'm fine, Your Honor. Good afternoon. I'm sorry for being late. I'm just getting here from Judge Adams' hearing.
Okay. Well, I'm glad you made it out of that. Do you have one of the 61 defendants?
Not that case, Your Honor. No,
Okay.
not that one.
Got it. You different matter. All right. We need to get an interpreter lined up. And once we do, we'll bring your client out and we will do the final plea discussion. Okay.
Thank you, Your Honor.
Thank you. Abdullah Sabri.
I'm gonna reach out to him. I spoke to him last week, so I do expect him.
All right. We'll hold on that. Tiara Chapman. Hey, Ms. Chapman. Your lawyer is Ms. Cabrera? Okay. Okay. Do we have a report from her, Ms. Nelson?
Yeah, she said that she does not represent her, that she hired an attorney. I do not have the name of the attorney that she hired.
Well, let's ask Ms. Chapman. Ms. Chapman, Ms. Cabrera reached out to you could hear what Ms. Nelson said.
I think originally I was supposed to hire attorney Ms. Gloria. 2 days ago, she tried to, I guess, get some paperwork from the courts, and they told her that an arraignment had already been put in by, I guess, the first person's name that you called out. So she wasn't able to, I guess, do anything.
Well, we're way past arraignment.
My first time ever coming to court was just before the, I guess, the arraignment, I was told.
Right, back in August, right?
So I had not heard anything or spoken to anybody about the situation in her case since then.
Well, Ms. Cabrera seemed to understand that you were hiring someone else.
I spoke to her this morning. So me and her between yesterday and this morning, this just transpired that I spoke with her. My first time hearing her name was 2 days ago from Ms. Gloria, and she was trying to contact the courts, I guess, and get documents from me, for myself.
Okay.
So that was my first time hearing Ms. I don't know how to pronounce her name, Ms. Saboro's name. So we reached out to each other yesterday and we kind of spoke. And I spoke to her briefly this morning, right before I just came in. She said she would reach out, I guess, to see what we could come up with. Like I told her, I had never spoken to anyone about my case. I have never even stated my side or anything. Like you said, I know we're past that point, but I've never.
Well, first, you're never past you've been able to tell your story. Don't worry about that. That would be trial or a plea, and so we're not there. You will get to tell your side to a lawyer first who represents you, and then ultimately to me or someone when that time is appropriate. Ms. Gloria is a lawyer, and that's someone you reached out to. Okay, so you've been trying to talk to a lawyer. That lawyer was Ms. Gloria. You're just not remembering her last name? Why don't you do that, and then we'll talk a little bit more, okay? Thank you. Brian Howell? Hello, Mr. Howell.
Yes, how are you doing?
I'm okay. Ms. Wood?
He's fine, Judge. If we could just hold, I would like to speak with 88 Clark about this case to see if we can resolve it today.
Sounds good. All right, Mr. Howell, we'll talk more today, so you can take a seat. Please don't go anywhere. And then finally, we've got Mr. Isaiah, who I saw online. Ms. Wood, what are we doing with Mr. Isaiah?
Same announcement, Judge. I would like to see if we can resolve it today, so I can speak with Ms. Clark.
Okay, and you've got good contact information for Mr. Isaiah?
I do.
If you need to give him a call?
If I need to, yes.
Okay, all right. And Mr. Muhammad is on now, so why don't we?
Yes, I'm Mr. Isaiah.
Yep, you're good, man. Your lawyer's gonna talk with the prosecutor and then get back and we'll talk more, okay?
Yes, sir.
So don't go anywhere.
Yes, sir.
All right. So you can step out, or you got the name? Okay. WYNN? Okay, and is that who you plan on hiring?
Yes, sir.
Okay, how close are you to hiring her?
I was trying to, like I said, trying to do some or finalize a couple days ago when she started to try to get into, I guess, the motion of my case, stated that someone else was already over it. So,
Well, because we appointed a lawyer to represent you, you can always hire your own attorney, which it sounds like you've started to do. I just need to know when that's going to happen. And Ms. Wynn would need to file an entry of appearance saying, no, I'm Ms. Chapman's lawyer. So maybe you could reach out to her to see this before you leave here today, so I could get a timeline for that, okay? All right, why don't you do that and let me know? All right. So let's try to do this in an orderly way. Mr. Muhammad, can you hear me?
Yes, I can. How are you?
I'm all right. Mr. Bryant? Where are you? You come on up to the podium, please. All right, you're tall. Can you angle that TV a little bit so your face is on it? Don't break it, just angle it. You just two-handed, don't snap that thing off. There you go, there you go. See, perfect. Now we see you. Okay. Mr. Muhammad, I learned that you very recently were brought on board. Mr. Bryant hired you. You filed an entry a couple weeks ago, maybe?
Yeah, Judge, I did receive an offer, but I don't know if the state sent discovery over yet, and it's somehow a breakdown on my part. So I wanted to confirm with them if they had sent it.
So I don't know that state necessarily served discovery. They had served Ms. Wood. And so you as the newcomer would have reached out to Ms. Wood to say, can I get discovery? But it sounds like you need some time to get that, to talk with Mr. Bryant about how to sort this out.
Right. Is it possible to get another final plea date for this case?
What I think I will do is, since we've got all the right people in the room, make sure that discovery will be heading your way, but I think we'll leave it on the trial calendar, but we will preserve Mr. Bryant's final plea rights. I don't want to slow this down because Mr. Bryant at the last minute decided to switch attorneys. He's got a right to do that, but he doesn't have a right to slow things down because that happened. So, Ms. Clark, is this a case with particularly voluminous discovery?
No, Your Honor, it is not. So I will get that over to defense counsel by tomorrow.
Would it be a evidence.com link or?
It will be evidence.
All right, so Mr. Pardon me?
I'll have my legal assistant, sir.
Great, thank you, legal assistant. So Mr. Muhammad, I'm gonna assume that you get that discovery by tomorrow, which is, I don't think our clock is right anymore, which is Wednesday. The clock says Wednesday.
Okay, so, yeah, I'll meet with Mr. Bryant by Friday and, hopefully we can figure out which direction this is headed.
Good. Yeah. So you know, the trial calendar is called on December 1. So it's about 3 weeks out, and it's the first 2 weeks of December, the 4th and the 10th, or the 11th, whatever that math would be, are the trial weeks. And I know that is soon for a lawyer just getting on the case, but the case has been around for a while, and excuse me, it doesn't sound like it's one with a whole lot of complicated facts. So you'll have discovery as of tomorrow. I will preserve Mr. Bryant's final plea rights, and Mr. Bryant, at the latest, I will see you on December 1. If you and Mr. Muhammad work something out with the state, we can always sort it out before then, so we don't have to wait that long.
Right.
Do you have any questions?
Oh, so I don't.
All right, let me look up one thing here. Oh, this is one of these old aggravated assaults. You got your bond way back. It's 3 years old. All right. So your bond order, you're not wearing an ankle monitor, are you? Good.
Never had one.
Good. We just have learned that some people have been wearing them for 2-3 years, and we need to get them off, get them on someone else. You're supposed to really not any conditions of bond. All right, show up for court. That's the main condition of bond. Did you get something in the mail telling you to be here today?
I did.
Good. So we got a good address. You and Mr. Muhammad talk. He'll get that discovery, and as I said, at the latest, I'll see you on December 1, and we'll see what happens with the case. Mr. Muhammad, anything else on behalf of Mr. Bryant?
Nothing further.
Ms. Clark, anything on behalf of the state?
No, Your Honor.
All right. If you don't have any other questions, Mr. Bryant, you are free to go.
Appreciate it.
Thanks.
Thank you.
So, Ms. Wood, I want to go back in order if we're not doing pleas. Is Mr. Daniels, he just needs to hear again what the offer is, and it's going to be a no thank you?
Yes.
Okay, let's do that. Ms. Clark, you ready for the first 3 positions?
Yes, Your Honor.
All right, if we could bring Mr. Daniels out, and your call, whether he's seated or at the podium, whatever's easier for the deputies. Mr. Strozier, how are you?
I'm very well, Your Honor. May I make an inquiry, please, sir?
Yeah, well, I was going to actually make the inquiry of you, wondering where your client is, Ms. Strodder.
She's supposed to be here, Judge. She knows to be here. My office just advised me that they received a Zoom link today. I had no idea this was available by Zoom.
It is. I think Ms. Strodder was supposed to be here in person, but either way, she's not on the Zoom. So if you want to spend a little time trying to track her down, otherwise, I assume the state will be seeking a bench warrant for Ms. Strodder.
I sure did. Do we want to talk about the status of the case? We're going to try to track her down first.
Try to track her down first.
All right.
Thank you.
I'll report back in just a moment.
Okay.
Thank you.
You bet. All right, let's go on the record, please, with positions 1, 2, and 3. All involve Mr. Daniels, who is here in court with his lawyer, Ms. Wood. Hello, Mr. Daniels.
Hey, Your Honor, how you doing?
I'm about the same as last time I saw you. Mr. Daniels, we're going to talk about where your case is and where it's going next. Ms. Wood, do you have all the discovery you're expecting in these 3 cases?
Yes, Judge.
All right. Ms. Clark, what is the state's offer if Mr. Daniels wanted to resolve his 3 cases today and still have that ability to withdraw his plea if he didn't like the sentence he got? What's the state's offer?
The state's offer in this case, Your Honor, was a successful completion of the RSAT program.
So are these wouldn't be probation revocations, so it would be a plea, and then a sentence, and RSAT would be through the Department of Corrections, which is not something that I can impose, I can only request it. So there'd need to be a custodial portion to the sentence for that to work.
Okay, so the notes that I have from 88 Peoples was that it was a sentence of 3 years confinement, but it was a successful completion of the RSAT program.
Got it. Okay. That makes more sense. And I think for a number of these, the 3 years was the maximum. The theft by shoplifting, what was I'm not the one who comes up with the offer. So you're saying it's 3 years to serve, but with a recommendation of RSAT, in which case Mr. Daniels could get out earlier, and get into the aftercare.
Yes, Your Honor.
Okay. Mr. Daniels, do you understand what the state's recommendation would be if you decided to enter a plea today to all three of your cases?
Yes, Your Honor.
Okay. Is that an offer you're interested in pursuing today?
No, Your Honor.
Okay. You understand that I will see you next on December 1. That's when we call the trial calendar that your cases are on. And that if you end up going to trial, I won't ask you what you think about the sentence. If you're found guilty, I'll just impose a sentence. Today is a little different, but after that, if you either decide to enter a guilty plea or you go to trial and you're found guilty, I will certainly hear from Ms. Wood and she'll tell me what she thinks the right answer is in terms of sentencing. But it's not a situation where you can withdraw either that plea or I don't know what you'd withdraw if there was a trial, but it'll be different than today. You understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Okay. Ms. Clark, anything else on behalf of the state?
No, Your Honor.
Ms. Wood?
No, Your Honor, thank you.
Okay. Mr. Daniels, we'll get you brought over on December 1 and we'll talk one more time about, is this a plea or is it going to be a trial? Do you have a sense yet, and it's early, so it's okay if you don't, Ms. Clark, which of the three cases you would try if we're going out on Mr. Daniels's cases?
Your Honor, the position 1 or position 2, but position 1, like, because it's the possession of controlled substance in Schedule 3 or 4.
Okay.
So, yes, or, yeah, the possession,
You don't have to decide today.
Okay.
I wasn't sure if you knew, but you'll want to look over those. One is pretty old and might be a little more complicated. Actually, none of them is particularly new, but I'll let you work through that. Okay. Mr. Daniels, we'll see you on December 1.
All right.
Thanks. And we're going to do Mr. Salmeron-Abara next because we have translation services here. So Mr. Brown, if you could pop on, there you are. Let's add you to the spotlight. Pardon me? Mr. Sabri? He's here. Great. All right, Ms. Wood, you're in luck.
Thank you, Judge.
At a podium?
I think I can.
All right, let me swear in the interpreter first. Ma'am, do you swear or affirm that you will translate to the best of your ability from English to Spanish and Spanish to English?
I do, Your Honor.
Thank you. This is position 11, indictment 23, SC 187796, State versus Ruben Salmeron-Abara. Today is the final plea hearing for Mr. Salmeron. Mr. Salmeron is here in court His attorney, Mr. Brown, is appearing virtually on the screen, and Mr. Shapiro is here for the state. Mr. Brown, do you have all the discovery you're expecting in this case?
I believe I do now, Your Honor. I was looking through the discovery. I didn't see the indictments, but Mr. Shapiro emailed them to me. I printed them out, the original indictment and the re-indictment, so I have them, and I have the warrants. I couldn't find the warrants in the discovery, but Mr. Shapiro resent them to me, and he also advised that they were in the discovery. I just couldn't find them. But I believe I have everything now.
Got it. Okay. Mr. Shapiro, what is the state's offer if Mr. Salmeron were interested in resolving his case today?
Judge, the state extended a global offer for all the offenses in the new indictment of life to serve 25 years in custody with the balance on probation. That would apply to counts 1 through 3 of the indictment. And then as to counts, I'm sorry. Yes, yeah. And then judges to counts 4, 5, and 6, the state's offer was 20 years to serve 19 in custody with the balance on probation. Those counts would all run concurrent. So again, global resolution of life to serve 25 years in prison.
Okay, so to break it into the custodial piece, 25 years to serve, credit for time served, followed by a lifetime on probation.
That's correct, Judge.
Got it. Okay. Mr. Salmeron, do you understand what sentence the state would recommend if you entered a plea today?
No le entiendo.
I don't understand.
Okay. If you were to plead guilty today, the state would recommend that I sentence you to 25 years in prison. Do you understand that?
Sí. Yes.
You'd get credit for the time you've been in,
Crédito por el tiempo que usted ya estuvo en la cárcel.
and then you'd need to serve the remainder of that balance.
Por 25 años todavía en la cárcel.
Do you understand that?
Esa parte. Sí. Yeah.
After you were released,
Salga de la cárcel.
you would then be on probation
Bajo probatoria.
for the rest of your
Por
life.
el resto de su vida.
Do you understand that?
¿Tiene usted esa parte? Sí. Yes.
Okay. Is that a sentence you are interested in pursuing,
Aceptar
or do you want your case to go to trial?
juicio.
Your Honor, before he answers that,
Antes de que
Sure, don't answer, Mr. Salmeron.
yes, before he answers that, well, now that I feel like I have all of the discovery, I do want to have some time to go over these warrants, the indictments, and the rest of the discovery with him before he commits to a yes or a no. I don't know if it's possible, Your Honor, if my client's case can be continued to another final plea calendar.
So what I'm willing to do, Mr. Brown, is to, one, I don't want to slow down Mr. Salmeron's case anymore. He has been in jail far too long. But two, we can preserve his final plea rights, and we can have this same discussion when we call the trial calendar. He is on a January trial calendar. He is not on the December trial calendar.
Yes,
That would
Your
give
Honor.
you, I'm sorry, I didn't mean to interrupt you.
No problem, Your Honor. I was going to say that would definitely give me some time to go over all this evidence with him.
Okay, I was gonna say the same thing. That gives you time to meet with him. So let's do that. We'll just have this conversation, not about the discovery, but about whether he's interested in a plea when we call this to trial in early January, okay?
Yes, Your Honor. Please.
Mr. Shapiro, anything else on behalf of the state?
Judge, I was just going to announce for the court and for Mr. Brown, we'll be filing a request to specially set that trial date. We have one of the victim children resides outside of the state, and as well, both of the forensic interviewers for this case, one is currently living in Texas, another is on maternity leave through, I believe, mid-January. So I just wanted to make the court aware of that prior to filing our motion.
Sure, okay. I'm sure that makes life easier for Mr. Brown as well. It's unfortunate that the indictment number is now as new as it is, because that it falls in line behind others, because it's a case much older than the indictment number would suggest, but understand the need for a special setting. Mr. Salmeron, do you have any questions for me? Your lawyer will come see you soon and you can ask him many questions, but do you have any questions for me?
No, específicamente no tengo ninguna pregunta, solamente que, pues, darle las gracias por su atención. Es todo.
I don't have a specific question, but I just want to say thank you for the time you're taking.
The least I could do.
Lo menos que yo puedo hacer, señor.
Mr. Brown, you will be out to see Mr. Salmeron soon?
Yes, I will, Your Honor.
And do you have the resources to have an interpreter join you? Because you'll need one.
I think that's exactly what I'll need. I met with him last night and he understood me somewhat, but technical terms, he wouldn't understand.
Okay, but how does that work with GPDC? Do they help you out with that?
I'll check with Ms. Walker.
Please let Ms. Nelson know if you hit a brick wall there, and we'll see what we can do. But I think that's a piece you're going to want to have with you, is an interpreter when you're getting deep into the discovery.
Definitely, Your Honor.
Okay. All right. Thank you.
Gracias. Eso es todo, señor.
Gracias.
Your
Thank
Honor,
you.
if I can ask,
Si yo puedo preguntar.
does he have a bond on this case?
Fianza en este caso.
He does not, Judge.
No.
Probably not. He didn't have a bond before. Before you were involved, we did have a bond hearing, and there were both safety concerns and immigration and custom enforcement concerns.
De inmigración.
Got it.
Okay.
Yes, Your Honor.
Entendí.
All right. Thank you.
Gracias.
Thank you.
Eso no lo entendí.
I didn't understand that part.
Did or did not?
Did not.
Mr. Brown, your lawyer, was asking whether you had received a bond or bail in your case.
En su caso.
And I explained that you had been denied bond,
Pasado ya le habían negado una fianza.
and that wasn't something in the past.
Sí, porque esta es la segunda vez que yo vengo aquí con
This is the
usted.
second time that I'm here with you.
By a different judge.
Fue diferente.
No,
No.
es la segunda vez que yo estoy sentado aquí.
It's the second time I'm sitting here.
Okay, hold on.
Un momento.
So in December of 2020,
20.
3 years ago,
Hace 3 años.
you were denied bond by Judge Brooks. This would have been soon after you were arrested,
Inmediatamente después de que usted haya sido arrestado.
and there has not been a discussion about bond since then.
Fianza desde esa época.
So you and Mr. Brown should talk about that,
Brown tienen que hablar acerca de eso, ¿ok?
and that may be something that he wants to bring up with me.
Tratar conmigo.
Ok, porque cuando me arrestaron, nada más me sentaron en una, así como en una video, como ahorita, pero supuestamente ahí estaba mi abogado.
At that time, when I was arrested, they placed me like this in front of a screen, and supposedly my attorney was present.
Y el señor Brown es el segundo abogado que me ha visitado o que me ha visto a mí.
And Mr. Brown is the second attorney that has visited me or seen me.
So for many years, you did not get very thorough representation
Tenía una representación legal.
Nunca.
because people weren't visiting with you. Mr. Brown is different?
Brown es diferente ahora.
Pues nada más, la vez pasada el señor Mario, no recuerdo el apellido, era mi abogado.
In the past, Mr. Mario, I don't remember his last name.
Mr. Cladis.
Exacto.
Right.
Exactly. He was my attorney.
Él fue el primero que me fue a ver.
He's the first one that saw me.
Y me dijo que iba a ser mi representante.
He told me he was going to represent me.
Pero el día que vine aquí fue nada más para decirme que él iba a dejar mi caso.
The time that I came here was just to say that he was leaving my case.
Right.
Y ya no, y a partir de ese día ya
And
no
after that
supe
day, I didn't know.
hasta apenas con el señor Brown, que
Just
es el que
now
se
that I
encarga.
have Mr. Brown.
Yep. So Mr. Brown is your fifth
Es
lawyer.
quinto abogado.
Es el segundo que yo
Well,
The second that I see,
right. 3 of them never even came to see you,
vinieron a verlo.
which is why I said what I said, which is that you have not been very thoroughly represented.
Que no ha sido representado realmente.
Mr. Cladis only represented you for a little bit of all that time you've been in.
Todo ese tiempo que usted ha estado,
He had colleagues who represented you, but they didn't come see you.
pero no vinieron a verlo.
Mr. Brown is not going anywhere.
Ahora está aquí con
Here's your lawyer till your case is resolved. Trial, guilty plea, whatever happens.
aceptación de culpabilidad, juicio, lo que sea.
Okay?
¿Está bien?
Está bien.
That's fine.
All right. Thank you.
Gracias.
Thank you, Mr. Brown.
Eso es todo.
Thank you, Your Honor.
And Judge, that concludes my business. Can I be excused, please?
Yes, sir.
Thank you
You missing it here?
very much.
No, I don't believe you.
Always.
No Halloween candy for him. I think I saw Ms. Slaughter come in.
You did, Your Honor.
Good.
I would request a reset to the next final plea date. I just received discovery at an offer late Sunday night. And I'm in the process of converting that to a format where I can share with Ms. Slaughter. She doesn't even know the state's offer yet, but the state's requesting time in this case is going to, I mean, the discovery's not voluminous. It's not all that complicated, but I mean, given the state's current posture, they may force me to try.
Okay.
If they do, that's fine.
It is that's, you know, your client has a right to have a jury sort this out if it's not resolved through negotiations. Ms. Clark, what is the state's offer right now, just so I understand?
Your Honor, the state's offer is 10 serve 3. And counsel is right, it's the discovery is not voluminous, but it is very specific. And does paint the actual picture for the jury that the state believes it will. So if we have to go to trial,
We have to go to trial. Mr. Strodder, when did you get involved in this case?
It was recently, Your Honor. I mean, like I said, I filed for discovery immediately, but I just received it Sunday night. And I've taken a cursory look at it. I stopped everything I was doing, but I mean, I need to thoroughly examine it. I need to sit down with my client. And like I said, my client has no criminal history. And if the state's looking for 3 years, we'll tee it up.
Okay. Thank you.
I don't have any problem with that. I just wanted Cobb County a couple of weeks ago. I've got the hot in it.
Okay. Well, then you should want to go to trial right away instead of delaying things.
I mean, I need to do a thorough job of preparation and with my client.
Yep.
But I mean, the state's asking for 3 years on a lady who doesn't have any criminal history stuff, and no real injuries here. So I haven't had an opportunity to pre-trial with the state either. I think that might be fruitful as well.
It would. So I'm just looking at the calendar here. Ms. Strodder, have you always lived in Atlanta?
Yes.
Okay, all right. Ms. Clark, do you, I'm just playing through my head, do we move this to a different trial calendar and just preserve the final plea rights, or put this on another final plea so that you and Mr. Strodder have a chance to talk more about the case? Do you have a preference one way or the other?
Your Honor, I would just like it to move to the next available trial calendar. Hitting somebody, the victim in this case is hit with a car, so it's pretty much, my offer's not gonna change.
Well, you've got it. Let's do this, Mr. Strodder. I'm gonna, two things. One, I'm gonna preserve Ms. Strodder's final plea rights, meaning if you and the state reach a point where, even if it's a non-negotiated plea that you put up, Ms. Strodder can withdraw that plea if I sentence her to more than you ask for on her behalf. So I'll preserve those rights. That's what today was the deadline for, but I'm going to preserve those rights. Ms. Strodder's case is on our December trial calendar. I'm going to leave it there. I don't think we reach this case on that calendar because it is new and she's on bond. And I got a bunch of other cases on there where they are older cases with people not on bond. But that'll keep everyone focused. You talking with Ms. Clark talking with you about possibly resolving the case. And if we don't reach it in the December trial calendar, that'll just keep it in the trial track so it could roll over to January, okay?
Judge, let me ask you something. I just heard you set somebody down for a January trial calendar. Can't you do that for Ms. Strodder as well? I just got discovered, I'm not running away from trial, but I don't want to be jailed either.
Okay. Is there something about discovery that you think is gonna, we're talking about a trial calendar that would start a month from now. And I don't know, I'm sure you got other things on your schedule, but is there something about this case that you think you need the extra time for?
No, sir, it's just, it's electronic, it's video, and, I'm old as dirt, Judge. Technology's not my friend. I gotta share it with her, and sit down with her, and I'd like to sit down with Ms. Clark too, although I heard what Ms. Clark said, so,
But you still should sit down with her after you've had a chance to do it. So, meaning review the discovery. So we'll move this to the January trial calendar. All right, but I'll expect you to be ready to go for that January trial calendar.
I'll be ready. I'll be ready to announce ready with no bullets.
All right, appreciate it. So Ms. Strodder, let me find.
So what day in January is that going to be, Judge?
Hold on a second. So you are on bond. You're supposed to stay away from a Ms. McClure and an address on West Peachtree. You're able to do that? Okay. Good. Keep doing that. I think it is the 10th. Mr. Strodder, the trial calendar is called on January 10th. And it starts actually a lot later than that because there's a holiday and things like that. I think it might not start till the very end of January, but we call it on January 10th. So you're actually going to get extra time. But I will see you and Ms. Strodder in court on January 10th for the call of that calendar.
All right, sir. So that's January the 10th. At what time, Your Honor?
We're calling it at 1 p.m.
All right, is that going to be live or Zoom or both?
Trial calendars are live.
Okay.
So we'll have everyone here.
All right, so the 10th at 1 p.m.
Yep, and you'll get that calendar. It'll be published and sent out to you, but you've got advance notice of it.
I'm going to stick it in my calendar now.
Excellent. Thank you.
Thank you, Judge. May I be excused?
Yep. Ms. Clark, anything else from the state on that case?
No, Your Honor.
All right, thank you.
Ms. Clark, may I call you, please?
Of course.
Okay.
Yes, sir.
Okay, back to our regularly scheduled. Mr. Flint, Oh, Mr. Luemba is around. He was stuck. He's here. Great. He was stuck in another courtroom. So let's handle that now. Mr. Luemba, can you? Oh, Mr. Flint, you left? Where are you? We'll come back to that. All right, Ms. Hollman?
Yes.
Yeah.
I spoke with Ms. Feely, reviewed the notes from Mr. Jordan, confirmed a few details. State's gonna move to no cross. At this juncture, I've already submitted an order to Ms. Nelson.
Okay, Ms. Holloman, that's good news. That's not even a lower offer. The state is dismissing the charges in your case, okay? You're gonna wanna get a copy of that, and you'll get that through Ms. Feely. She'll be able to get it once I sign it, and you already have a copy?
No, that's something else.
Oh, okay, well, keep that too. I'm sure that's an exciting piece of paper, but the better one is the dismissal of your charges, okay? It what?
I'm gonna speak with you about how to do it.
Yeah, yeah, Ms. Feely will get it and she'll either mail it to you or scan it and email it, but I can now see it on the screen. I need to sign it. Okay, Ms. Feely will talk to you about that, all right? All right, you can go whenever Ms. Feely says you can go. And Ms. McCauley has managed to take care of her last piece of business and she can go. Thank you. How about Andre Williams?
That's a plea, and I know Ms. Marsh has somewhere else to report to, so if I got 1 second.
Yeah, no, talk with her, Ms. Marsh. Mr. Flint has now appeared and is at the podium. Can you come back, or you need to go as in go away and not come back?
I'm not sure. I have a couple of matters, but it's to Judge Ingram. I've already notified her, so
Okay.
I don't think this plea will take long.
Okay, so we'll do Mr. Williams right after we do Mr. Flint's situation.
Yes, Judge,
Okay,
thank
all right. So Mr. Flint is standing in front of us. Mr. Luemba is now added to the screen. And that is a Ms. Clark case. She is here. Excellent. Okay. Let's go on the record with positions 5 and 6, both Mr. Flint's case. Mr. Luemba, are you able to hear us?
I am. Can you hear me, Judge?
Yes, sir. Very clearly. Thank you. Mr. Luemba, do you have the discovery in these two cases?
I do have the discovery, Judge.
Excellent. Ms. Clark, Mr. Luemba, is this something that we're working out today, or should I get Ms. Clark to set the offer down so that Mr. Flint can say no thanks and we can put him on the trial calendar?
I've already relayed the offer to Mr. Flint. It's some things that he wants to work out in the offer. I do believe that once I work those things out with Ms. Clark, this is going to be a plea. This is not going to trial. It's a probation offer, but it's some things that some financial obligations that may come with the offer that he isn't currently ready to make. And so I would hope that we can set this down for the very next final plea. And I promise you, Judge, we'll be resolving this case.
Got it. So here's what's going to happen. No, it won't be on the next final plea. It's on a trial calendar that's already been published. And we will see you guys on December 1, but I'd be happy to see you before then if you've worked it out. And then you can just reach out to Ms. Nelson. And if it's probation, you can even appear virtually. We can take that plea because Mr. Flint won't be going into custody. So I'll let you and Mr. Flint and Ms. Clark see if you can iron out the last remaining details. And if you do, reach out to Ms. Nelson and we can tack you on to whatever calendar we've got. It can be in person, it can be virtual, whatever works best for you and Mr. Flint. But failing that, I will see Mr. Flint in person and you, Mr. Luemba, in person for our December trial calendar that has been published. So you've got it. It is December in the afternoon is when we call it. And it could be that we take the plea then. I'll just alert you that that will be a congested afternoon. And so it'll work better for you all if you sort it out in advance that we see you before then. Does that work for you, Mr. Luemba?
It does, Judge.
Okay. Mr. Flint, do you have any questions about any of that?
No, sir.
So it sounds like at long last, because you and I have been working together for a minute now, we're resolving both your cases. You got a lawyer who, as I told you, was sticking with your cases. and we will take care of both of them. I thought today, but Ms. Clark, there is a financial piece to the, I'm just looking at the charges and trying to understand how there'd be money in the mix.
Your Honor, in my offer, I think I indicated that a drug evaluation, but let me make sure.
Well, you don't have to poke around. Mr. Luemba, what's an example, or do you just need more time with Mr. Flint? Because
just more time with Mr. Flint, Judge, and he's concerned about probation.
okay, meaning the impact it will have on him.
Yes, he's concerned about probation fees, and that's something I want to talk to Ms. Clark about. If that's something that can be waived, then I would go over the waiver with him, the waiver right form, and we'll be ready to take the plea. But he's really concerned about those probation fees and his employment situation. He doesn't want to set himself up for failure.
Got it. So a couple things on that, Mr. Flint. I'm never going to lock you up because you can't pay your probation supervision fees. One, that's not a big number. Two, I would never lock you up for that. Sometimes we turn them into community service. If you don't have the money, then let's do some community service instead. Are you working?
No, sir.
Okay. Have you been working?
No, sir.
Have you been looking for work?
No.
Why would that be?
I don't know.
Okay, well, then you ought to be concerned about probation supervision fees. I would likely, as a condition of probation, say you need to be looking for work. So you might want to start gearing up for that anyway. But you and Mr. Luemba can talk more about that. I don't mind waiving the reporting fees for the first few months of probation anyway, if you're actively looking for work. But if what you're doing is sitting on your rear end and not looking for work and not working, then I'm not real interested in waiving the probation fees. So maybe you'll focus on that some between now and the next time I see you. But just know that that'll be at the latest our trial calendar call, and you ought to be there on time. Okay?
All right.
All right. Mr. Luemba, anything else?
No, Judge, I'll be in contact with Ms. Nelson. I think you're going to see us before December 1st.
Fantastic. Ms. Clark, anything else?
Nothing from the state, Your Honor.
Okay. Mr. Flint, you're free to go.
Appreciate it.
Thank you, Judge. Not being accused.
Yes, sir. All right, Ms. Marsh, it's up next anyway. Let's do Mr. Williams. Is this a felony or misdemeanor plea?
Misdemeanor, Judge. Count 2 in the indictment.
All right, let me know when you're ready.
Yes, Judge, I'm ready.
Okay, Ms. Feely, are you ready?
Correct.
Okay, this is position 7 on our final plea calendar, 22 SC 181649. State versus Mr. Williams, who is here in court with his lawyer. Ms. Marsh is here for the state. Mr. Williams, in just a moment, Ms. Marsh is going to put you under oath. Once you're under oath, you need to answer her questions and mine truthfully. You also need to let Ms. Feely or me know if you've got any questions. Will you do that?
Yes, sir.
Okay. And you're pleading to a misdemeanor. We'll see what all the specifics are when I hear from Ms. Marsh, and we'll go from there. When you're ready, Ms. Marsh.
Thank you, Judge. Mr. Williams, please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. Please lower your hand. Please state your true, correct, and legal name.
Angela Williams.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you, sir?
49.
What is the highest level of education you have completed?
12th grade.
12th grade? So
Yes,
you
ma'am.
finished, you graduated high
Yes,
school?
ma'am.
Are you able to read, write, and understand the English language?
I am.
Do you understand that as currently you are charged in 2 counts in this indictment, with count 1 being aggravated stalking and count 2 being criminal trespass?
Yes, ma'am.
Do you understand, however, that the state is going to recommend that the judge allow us to no prosecute count 1 and allow you to enter a guilty plea to only count 2, criminal trespass, which is a misdemeanor?
Yes, ma'am.
And do you understand that the range of punishment for that charge is 1 day to 12 months?
Yes, ma'am.
Do you understand that you have the right to plead guilty or not guilty to this charge?
I do.
Do you understand that if you plead not guilty or remain silent, that you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have.
Do you need any additional time to speak with your attorney?
No, ma'am.
Are you satisfied with your attorney's services?
I am.
Ms. Feely, do you waive formal reading of the indictment?
We do.
And do you waive any and all defects in the indictment, including with respect to your client's name?
We do.
Thank you. Mr. Williams, do you understand that this is a negotiated plea of guilty, which means that the joint recommendation of the state and the defense to the court will be a time served recommendation? A little over 5 months, Your Honor. I had that he was in custody from May 13th of 2023 to October 18th of 2023.
On charges from 2018?
It was in judicial hold at some point, Judge, for a FTA.
Got it. Okay. Thank you.
Thank you. Mr. Williams, do you understand, however, first, do you understand that that's the recommendation?
Yes, ma'am.
Do you understand, however, that the court does not have to accept that recommendation and the court can sentence you to a maximum on this charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea, you have the right to withdraw your guilty plea?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that this plea may have adverse or unfavorable consequences? For example, for this misdemeanor plea, this may affect your ability to obtain employment.
Yes, ma'am.
I'm going to go over several rights with you. I'm sure your attorney already spoke with you about them, but I'm going to read them to you and then ask you whether you understand, okay? So by entering this guilty plea, do you understand that you're giving up the right to a trial by jury, the right to remain silent and not incriminate yourself?
Yes,
the
ma'am.
right, I'm going to go through them first, sorry. Thank you, though.
Right.
The right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. First, did you understand all of those rights as I read? And do you understand that by pleading guilty, you're waiving all of those?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to count 2, criminal trespass?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have 12 months from today's date for this misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, sir. Your Honor, should this case proceed to trial, the state expects the evidence to show that on March 26th of 2018, the named victim, Ms. Kemi, Kemi Jackson, took out a TPO here in Fulton County under case number 2018 CV 302878. Your Honor, however, on the date of April 14th of 2018, officers were dispatched to Ms. Jackson's location, which was her home, and Mr. Williams was at that location. He had been criminal trespassed by security to not go to that location, and that was 765 McDaniel Street Southwest. That is here in Atlanta, Georgia, Fulton County. Your Honor, the reason that the state is offering just the criminal trespass as opposed to the aggravated stalking is because it has come to my attention that the TPO was actually dismissed a few days earlier on April 5th of 2018. However, Judge, the state does still believe we can prove the criminal trespass because Mr. Williams was trespassed from the property by the apartment complex and not Ms. Jackson. Your Honor, Mr. Williams does have an extensive criminal history. The state is not ignorant to that. However, we do think that this is the best resolution to fit the facts in this case. And that is all I have, Judge.
Thank you. Ms. Jackson, I'm curious about number of cycles and felony convictions, please.
Yes, Your Honor. He has 65 cycles. The last arrest was February the 5th, 2021 in Gwinnett County for a failure to appear. He does appear to be on probation in Gwinnett County, felony theft by shoplifting. That disposition date was April the 26th, 2021, and the term is for 10 years. And he does have prior felony convictions. One in 2021 out of DeKalb County for theft by shoplifting. An additional one in 2021 out of DeKalb County for theft by shoplifting. It's another one in 2021 out of DeKalb County for theft by receiving stolen property. One in 2012 for aggravated assault and burglary. One in 2002 out of DeKalb County for aggravated stalking. That's it for us, the felonies, Your Honor.
All right, thank you. Ms. Feely.
Thank you, Your Honor. Mr. Williams was before the court in August for the failure to appear situation. And my understanding from my notes and from speaking to Mr. Williams again is that his probation for the Gwinnett shoplifting probation was violated because of this arrest. And so then he went to Dooley State Prison where he did RSAT. And then he did RSAT at Coastal, and then he went to Wilcox, and then that's why he failed to appear, because he was in DOC. So that's why the long gap of time. But this is a situation that involved his ex-wife, and he has not had any contact with her since 2018. He is a crim high school grad in 1993. Since he's been out on the bench warrant that Your Honor lifted, he's gotten back into the landscaping that he'd been doing. So we are asking the court to accept the state's recommendation.
Okay. Mr. Williams, it's soon going to be cold and the landscaping is done because all the leaves have been blown away and all that kind of stuff. What do you do in the winter?
Well, it depends on what my boss have. He have like a little cleaning service also, so we'll jump into that in the wintertime.
Okay, so he's multi-season. He can keep you busy and employed and paid.
He tries his best.
Year round.
Yes, sir.
Okay. All right. And Ms. Jackson is your ex-wife. You haven't been around her for a while.
No, since 18.
Got it. Any questions about anything?
No, sir.
Well, Mr. Williams, I find there's a factual basis for your plea, and your plea is knowing and voluntary, meaning you've understood what we talked about. No one's forcing you to do this. I will follow the joint recommendation and sentence you to 5 months to serve, but give you credit for the 159 days, I think it is, that you've already served on this case. So you do not go back into custody. This one's closed out. You do have a pretty rich criminal history, and I share that with you only because you're 49. You want to stop getting arrested now, because at some point a judge is going to say, "Woo, this is too many," and you'll be out of commission for a while, and that won't be good. Do you authorize, Mr. Williams, my staff to sign the indictment indicating your guilty plea?
I do.
Ms. Feely, can we sign for you?
Yes, Your Honor.
And Ms. Marsh?
Yes, Judge.
All right. I think that is it. There's no probation piece to it. So Ms. Marsh is correct. It was quick. Good luck with everything.
Thank you so much.
All right. Thanks, Ms. Feely. Thank you, Ms. Marsh.
Thank you, Judge. May I be excused?
Yep. Let's talk about Ms. Chapman, because Ms. Cabrera is here, Ms. Chapman is here, and then we'll go back to Mr. Sabri, who's been here for a little bit.
Thank you,
And we'll see what we're doing. Hello, Ms. Cabrera.
How are you?
It's good to see you.
Yes, good to see you.
So, let me just tell you what Ms. Chapman was sharing, that she recently had reached out to Ms. Nguyen about possibly representing her. I looked at the docket and saw how you had stepped in, and I think you were appointed.
I was appointed. I did a waiver.
Yep.
That day she came to court, and she announced that she would be hired. At that time, of course, Ms. Nelson didn't give her any contact information for me.
Right. We just sort of froze things because we were honoring Ms. Chapman, your claim that I'm going to be hiring someone. But it sounds like then this date crept up on her, and she hadn't necessarily done that.
Right, and so I reached back out, I contacted Ms. Nelson, I said, let me get a contact number for her, because it came up on the calendar, but my name was still on.
Yeah.
So I said, all right. And then I reached out to the state. State was able to provide me with an offer, go through. Of course, they sent me a link, I think right after that arraignment calendar. But there was issues with the link. They sent me a new link so that I could attempt to open everything again, sent me an offer. I finally was able to, after a couple of messages, actually get in touch with Ms. Chapman. And then Ms. Chapman told me again, she said, yeah, I did hire, and her name, at the time, she was Miss Gloria.
Yeah, that's what it started with today,
Right.
Miss Gloria.
Right, so she said she'd hired Miss Gloria, and I said, okay, pause. I said, there's nothing else for me to do.
Right.
I left it alone. And then, but I wasn't asking the right question. The right question was Miss Gloria paid? And I asked that question today.
Got it.
Because she said she sent me a message last night, which I missed. So she called me and she says, I need you to be there. I said, well, where's Miss Gloria?
Yeah.
And she said, well, that's not happening. I said, wait, did you retain Miss Gloria? And she said something else. And I said, wait. I said, did you pay Miss Gloria? She said, no. I said, okay.
Now we all
So
understand.
here we are. It sounds like Miss Gloria attempted to look up some things or what have you. Saw my name was on there and instructed her to find out what the offers were and whatever. I am happy to talk to Miss Gloria to find out if she, because I've done nothing with it.
Sure.
I'm happy to talk to her to find out if in fact she wants anything that I have.
Yep.
And if she's going to represent her. If not, then I'll continue forward and represent her.
But we may need to tap the brakes a little bit because you understandably have said, I shouldn't work on this because Ms. Chapman was intending to hire someone else. And I'll hear from you in just a minute, Ms. Chapman. Ms. Clark, without going into lots of details, was the offer that you communicated to Ms. Cabrera or Ms. Gloria or wherever it's rattling around, is it probation or does it involve custody as well?
It involves custody.
Okay, that just helps me calibrate how much time I need to bake into this because folks are going to want to dive a little deeper in discovery than if it is a simpler potential resolution. Ms. Chapman, do you have anything you want to add? Not about the substance of your case. I don't want to hear about that right now. I promised you, you'll get a chance to tell someone your story. Could be Ms. Cabrera, could be Ms. Gloria, and ultimately me. But I want to know what your plan is. I don't know anything about your financial circumstances and how quickly you could hire Ms. Gloria.
Misunderstanding. I want to apologize for the misunderstanding. Of course, I was under the impression that Ms. Gloria was going to take the case, but upon speaking to her earlier, just not sure. So I would like the representation from Ms.
Cabrera Demore. Do you want me to reach out to Ms. Gloria at all, or is that going to be a no?
Let's just go for it with you and I would like that.
Okay, you'll be in very good hands. I have no worries about that. You guys can exchange contact information, so it's easy to reach. It sounds like you already had it, but you had just.
Really comfortable when I talked to her earlier.
Well, look at that. All right. Tell me what kind of schedule makes sense to you now that you know, oh, I own this.
So I'm at.
Well, and let me just give you the parameters. Okay. Ms. Chapman's case is on the December trial calendar. Right. I doubt we would reach it on that calendar because she's on bond and it's kind of new, but I don't even want to put folks in that vice if, I don't know how much discovery is in this case, but you need a chance to deal with it. And I know you got other cases.
I would just ask, so if it weren't on this December trial calendar, whatever the trial calendar is after that, okay. I'm pretty sure I can get ready for whatever the calendar is that follows that.
Sure. It's January. It's called on the 10th, but the actual trial weeks aren't for a couple weeks after that because of Dr. King's birthday or observation, and then the judges conference. So. Okay.
And I'm just so that the court is aware, I told Judge Carnesale as well, I am going to be filing, it's not an emergency leave, but my family has surgeries and all sorts of stuff that they're trying to do. And so I'm going to file a leave for the last 3 weeks of December and the first week of January. I will be working. I just wanted to protect myself from court dates that I couldn't possibly make.
And so you may say I could come to this or that, not a 2-week trial, but you might be able to parachute in.
Still pop in. If there's a plea that can be done, I'll probably pop in to do the plea.
Great.
I just wanted to protect myself in that space.
Okay, but also good to give yourself some work distractions during those complicated times. What I'll do is have Ms. Chapman's case moved to the January calendar. That's a trial calendar. We'll preserve the final plea rights. We just won't have another final plea hearing. And then if you and Ms. Chapman sort something out with Ms. Clark, even if it's not negotiated, because she's got her final plea rights, just reach out to Ms. Nelson and we'll figure out a time to do that before that January date. But at least we've got that backstop, knowing that by then you'll have had time to do what you need to do.
Perfect.
Does that work?
works. That works.
Excellent. Any questions about that, Ms. Chapman? You feel like you got good contact information for Ms. Cabrera de Moore?
Yes, sir.
And
Okay.
when I step out, I'll go on ahead and talk to her because I'm gonna need her to send me some more information.
Good. Sounds like a plan. Ms. Clark, anything from the state?
No, Your Honor.
Got it. Thank you.
Thank you, Judge. I'm gonna, I'll let you know something. And I'll try to do that before the.
And if you can't, like if you get it, and it's a file.
All right, let's move backwards to Mr. Sabri. Oh, Ms. Wood stepped out. Well, but she's got the next one. She's got all of them. You know, is she coming back?
Yes, but we also have Mr. Nukem from the other calendar.
Okay.
We want to try to do that. I can
Um,
go grab her, if you'd rather.
if Mr. Sabri is going to be a plea, then let's do Mr. Newcomb. If Mr. Sabri is there she is. It's not a plea. So let's take care of Mr. Sabri so he can be on his way, and then we'll figure out what we do with the last few things we've got. Because we also, Mr. Isaiah has been sitting on the screen for a while too.
And that will be a plea, Judge.
Okay, got it. And what happened with Brian Howell?
He's right behind me, Judge.
Oh, he's out, he's here. Okay, good. So let's go on the record with position 12. This is 23 SC 187912. Have I been mispronouncing your last name?
No, you said it correctly.
Great. This is State versus Sabri. Ms. Clark represents the state. Ms. Wood represents Mr. Sabri. And this is the final plea date. Do you have all the discovery that you are aware of, Ms. Wood?
All that I'm aware of, Judge. yes.
Okay. Ms. Clark, what is the state's offer to Mr. Sabri?
Your Honor, in this particular case, in speaking with the victim, I was going to reduce it down to criminal trespass and offer 12 months probation.
Okay. So, Mr. Sabri, today, if you were interested in resolving the case by way of a plea, the state would reduce the felony to a misdemeanor and recommend 12 months probation. You understand what the state's offer and recommendation would be?
Absolutely.
Okay. After today, the state may make you an even better offer, but they also could go back to say, we indicted Mr. Sabri for a felony, and they could say, we're going to go forward with the felony, which is different from a misdemeanor. You understand that this offer today is not binding on the state after today.
Absolutely.
Okay. Today, if you entered a plea to the misdemeanor, and Ms. Wood recommended something less than the 12 months probation, if I sentenced you to more than what Ms. Wood asked for, you could withdraw your plea. You understand that?
Absolutely.
Okay. After today, you're free to enter a plea if that's what you decide is in your best interest, but you won't be able to withdraw it if you are dissatisfied with the sentence you get. You understand that?
Yes.
I think you understand everything. So, Mr. Sabri, are you interested today in entering a plea to the misdemeanor of criminal trespass?
Actually, I was wondering if I could get this whole thing dropped.
So there's a great question, and I bet Ms. Wood is going to keep pressing for that, but I don't have the authority to drop a case. You were here, been here all the whole time. There's a young lady sitting in the back who got her charge dropped. Don't know the facts and circumstances of that. Actually, I now know, having read something. But the prosecutor there said, you know what? For these reasons, Judge, we're dropping or dismissing the charges. Things are trending in that direction for you, in that the state has moved from a felony to a misdemeanor. At least today they have. I don't know that that will persist, but that's what's happened so far. But I don't have control over that. I don't get to reduce charges. I don't get to dismiss charges. Judges don't have as much power as people think. So the state's offer right now is a misdemeanor probation plea. And so my question to you is that something you're interested in pursuing, or do you want to say no thanks, and I will see you on December 1, and we'll see what happens then? And if you want to talk with Ms. Wood for a couple more minutes, that's okay. It's your case, not mine. I can turn and take the plea with Ms. Feely.
Yeah, I'll talk.
You want to talk a little bit more? Smart choice.
Your Honor. Also, I wanted to say if an attorney Wood can let me know if there is mitigation or other additional information that that the defendant would need for the state to consider in this case. So let me know that as well.
Sure, I bet she will. I bet Mr. Sabri and she will talk about that, and this will be a work in progress. Ms. Sims, do you need a break or are you good?
I think I'm good.
Okay, let's do another plea and then I'll check back in with you. All right. We got about 9 deputies in here. Are we good? All right. Should we bring Mr. Nukem out and do that?
Yes, he is, as we all know, competency is a very low threshold, and he's been found to meet it, although I have not seen the order at this point. Ms. Ross, does the court have the competency order?
Ms. Nelson, do you have, if you have a copy of the order in Mr. Newcomb's case, that's number 3 on this morning's calendar, if you could email that to me, please. Just so you know my practice, I get them and read the whole thing, and if it's competent, we get it back on a calendar, and then I delete it. I don't want to be holding on to it. Ms. Nelson usually keeps them, and then there's always Ms. Green, who pops out of jury room sometimes, who always has a master list of them.
But just so the court knows, he is trying very hard to focus, but
Okay.
he is very distractible.
Okay,
And-
well, let's keep this one real simple.
Yes, that's my hope.
Okay, when you guys are ready, let's bring Mr. Newcomb out. You want some of this candy?
No, I'm not feeling too well. So is
Uh-oh.
it okay if I sit down?
Yes, please. And if you need someone to come sub for you, reach out. I'm sorry, do we need to stop or you?
I should be good. As long
Okay.
as I can sit down.
Okay, do sit.
Just gonna answer the question that I asked, okay?
Yes, ma'am.
Hey, Mr. Newcomb, how are you?
Yes, sir. I'm all right.
I'm Judge McBurney.
Yes, sir.
And Ms. Feely told me that you're interested in resolving your case today. Is that right?
Yes, sir.
Great. We're going to have a conversation, 4 of us, Ms. Clark, who's the prosecutor.
Yes, sir.
I'm the judge, you're Mr. Newcomb, and Ms. Feely, your lawyer. And we're going to talk about your rights as a defendant. And I just need to make sure you understand all the stuff we're talking about.
Yes, sir. I read it.
Great. Will you let me know if you have questions about anything?
Yes, sir. Yes, sir.
Good. In just a moment, Ms. Clark is going to ask you to raise your right hand. Don't do it yet, to swear you'll tell the truth. And once you do that, she's going to ask you some questions. If you understand the question, you should answer it. If you don't understand it, let Ms. Feely or me know, and we'll explain it again.
Yes,
Okay?
sir.
We'll take all the time we need, and we'll just see where we get.
Yes, sir.
All right? Ms. Clark?
Yes, Your Honor. Also, before the state gets started, the state will be reducing count 1, theft by receiving stolen property felony, to theft by receiving stolen property misdemeanor, and going forward with count 2 as
Okay.
is.
So, Mr. Newcomb, you're pleading now just to 2 misdemeanors. Those are less serious than what you're charged
Yes,
with.
sir.
So that's a good development for you.
Yes, sir.
Okay.
Please raise your right hand. Do you swear or affirm the statements and testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under
Yep.
penalty of perjury?
Yes, ma'am.
Please state and spell your correct legal name.
BRYANCODYNEWCOMB.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am. Can I ask something? When you meant perjury, like I'm being charged with grand perjury or bank robbery?
Nope. 2 things. What she was letting you know is that now you're under oath if you knowingly say something that's not true, like if you were to say, my name is Fred Nukem, well, we know that's not your name. Your name is Brian Nukem.
Yes, sir.
You could be charged with perjury. That just means lying during this
sir.
conversation.
Yes, sir.
Larceny is taking something from a bank. You're not charged with larceny.
Yes, sir.
Okay?
Is there medication that you normally take that you've not taken or been given today?
No, ma'am.
How old are you?
31.
What's the highest level of education or the last grade you completed?
I went all the way till I was 18 in juvenile prison. And then I did Rosetta Stone through AIR, if you know what that is, the Rosetta Stone AIR Challenge through College Hills. And I got a master's degree in economics and another one in pharmaceutical managers.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have been charged with the following offenses? Count 1, theft by receiving stolen property misdemeanor, and count 2, possession and use of drug-related objects.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the indictment with your attorney?
This is it right here? Oh.
But yeah, we went over it.
So I'm being indicted too?
So you were indicted, and the question was whether you, and it wasn't worded quite this way, but the question is whether you and Ms. Feely have talked about the charges you face, this theft by receiving and the possession of drug-related
Yes,
objects.
sir. See, in the county jail, they don't give us our mail or nothing like that. And when I never received no motion of discovery of indictment, no verdicts, or no yellow data graphite. And it says that's illegal on the law library.
Okay, but you're familiar with the charges that you face?
Yes, sir.
Got it.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Attorney Feely, do you waive a formal reading of the indictment for purposes of this plea?
We do.
Do you waive any defects in the indictment for purposes of this plea?
We do.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading guilty today?
I was told time served, no probation.
So that's a great response. That might be what the recommendation is, but I also need to be sure that you understand if I disagree and I sentence you to the maximum, what would that be? And for each of these, it's a misdemeanor, it would be 12 months. So the longest sentence you could get through this plea would be 24 months in jail.
I've been in jail since June 1st, 2021. That's 5 years with good time.
Yeah, I don't know about the 5 years part, but I'm going to talk to you a little bit later about the time you've already served. I just need to make sure you understand that for each of these charges, the theft, maybe of the golf cart, and having maybe the crack pipe, those are both misdemeanors. Maximum 12 months in custody. You understand that?
Yes, sir.
Great.
Do you understand that you are entering a negotiated plea of guilty, which means the state and defense jointly will recommend the following sentence to the court? For count 1, theft by receiving stolen property, misdemeanor, the state's recommendation is 12 months to serve. And for count 2, possession and use of drug-related objects, which will run consecutive, it'll be 12 months to serve, commuted to the time that the defendant has already served. Is that your understanding?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 22 SC 183186, how do you plead to count 1, theft by receiving stolen property misdemeanor?
Guilty.
How do you plead to the charge of possession and use of drug-related objects?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am. What's the stipulation to me pleading guilty? Yes, ma'am. Cause I don't want to be walked or chair coast into saying guilty, and then y'all tell me 24 years or like 10 years of probation.
Right.
'cause
So
of trickery.
I hear you. No trickery.
My family's Mason, so.
So two things. One, I don't want to mess with any Masons.
Yeah.
But two, remember, you'll have a chance. First, you know what the recommendation is, which is time served.
Yes, sir.
If for some reason I do something more than that, you and Ms. Feely will have a chance to talk about it, and you can come back and say, no, thank you. I agreed to time served, not whatever I decide. So there's not gonna be any trickery here. I'll be very transparent about what sentence I'm gonna impose.
Yes, sir.
And then you'll have a chance to meet with your lawyer and talk and say, I trust that judge, I'll accept that sentence. Unless, of course, I go along with what's being recommended, then you've already said yes to that, okay?
Yes, sir, I understand.
All right, Ms. Clark?
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing what is called a habeas corpus petition?
Can you define that for me, what that means?
So a habeas petition, and don't worry about the Latin sounding name, that would be you basically filing a lawsuit saying my sentence was unconstitutional or my conviction was unconstitutional, if you were choosing to challenge this. Now, if you get the sentence that your lawyer is asking for, there's really not a reason to do that. But what Ms. Clark is letting you know is that you're always free to do it. You could change your mind and say, this was not fair. But there's a deadline in which to do it because this is a misdemeanor. It's not that 6 years from now you could say, I'm gonna challenge that conviction. Okay?
Yes, sir.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes, ma'am.
At this time, the state can provide a factual basis for the plea unless the defense will stipulate to a factual basis.
We stipulate to a factual basis.
And all that means, Mr. Nukem, is that your lawyer is agreeing on your behalf that the state has evidence to support this charge that you jumped into one of the Piedmont Park golf carts, drove it around for a little bit. And then maybe when the police caught up with you, you had something in your pocket you shouldn't have.
Yes,
That's all it is.
Yes, sir.
All right. Ms. Clark?
Nothing further from the state, right?
Okay.
So you said I'd been better off, I would have jumped it?
I don't know, maybe. Ms. Jackson, do you have any criminal history information on Mr. Nukem?
He has 19 cycles. The last arrest was January the 13th, 2022 with the City of Atlanta Police Department for misdemeanor obstruction of an officer. There was no disposition for that arrest. He has misdemeanor convictions, one in 2017 for disorderly conduct, An additional one in 2017 out of Douglas County for giving false information to an officer. Nothing in addition, Your Honor.
Thank you, ma'am. Ms. Feely?
In the interest of streamlining this, unless the court wants to hear from me, if it's okay, we don't have anything further to add.
Great. I have one question for you, Mr. Nukem, and I think we're good to go.
Sure.
You're going to get out in the next couple days. Where are you going to go? Do you have a home? Do you have
I've been locked up for so long, man. I don't know. I might end up back on the helium ass, if you know what that's at. Most likely Gateway, or I hope not the Peachtree and Pine Center.
Okay.
Or Gateway, and if not, I'll try to find a hotel with one of the.
Okay. You don't have family around here?
All my family's overseas.
Overseas. Okay. All right. Well, I hope that you are able to find a roof to put over your head. Mr. Nukem, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. That just means no one's forcing you to do this, and that you've understood what we talked about. And when you didn't, you did a very good job of asking a question.
Yes, sir.
Do you feel like you're in a good space now?
Yeah, but when I make this plea, I should be getting out of jail tonight, right?
So I can't promise you that it would be tonight, but if you are, today is Tuesday, ignore that clock.
Yeah.
Today is Tuesday. If you're still in Thursday morning, you should call Ms. Feely to say, wait, I'm stuck. And then I will call the jail and say, here's the paperwork. Mr. Nukem should have been released. But it'll probably be tomorrow. It just is late enough.
They usually let us go, like if you say time served today and I sign the paper, they let us go by breakfast time tomorrow morning.
I think that's right. I think by tomorrow morning, you're out looking for a safe place to stay.
I get a copy of this too that I signed.
You're not going to have to sign anything. I'll take care of that. I'm going to talk about that in just a minute. But to answer your question, you should be released tomorrow, which is why I'm saying if it's then tomorrow's Wednesday. So if you wake up Thursday morning and you're eating jail breakfast again, you need to be blowing up her phone. Hey, why am I still here?
I get confused because they usually call you out to cell at like 2 a.m.
Yeah.
So that's what you mean. So it probably today's Tuesday, right?
Correct.
So it should be Tuesday morning before breakfast.
Wednesday morning.
Today's Tuesday, right?
Today's Tuesday.
So okay, yeah, because it's weird how they do it around how they serve breakfast. You know what I mean?
Yeah, it's crazy.
You'll feel like when you say tomorrow, I'm thinking you're saying Thursday when it's really no. You're gonna go back to jail. You're gonna take a shower. You're gonna go to sleep, and they're gonna wake you up before breakfast until you pack it up.
There you go.
Yes, sir.
And I'm gonna
You
be
got it.
watching too.
Yes, sir.
Check
Because
on
they've been
to
holding
make sure
people
you're
hostage
released.
in there, man. I've been writing statements on them. See, I've been
Okay.
sued.
I don't,
Yeah.
well, today isn't the day we're going to talk about the hostage taking that they're doing there. Ms. Feely, is it okay if we electronically sign your name to the indictment for the guilty plea?
Yes, Your Honor.
And Ms. Clark? Mr. Nukem, is it okay if someone on my team electronically signs your name saying guilty to the 2 misdemeanors?
Yeah, I don't know what electronically.
It just means that someone's going to use a piece of software, and so it will say Brian Nukem like you had signed it.
I don't have a signature.
You don't have to sign it. It's just going to print it out.
All right, I get a copy of whatever my name goes on to.
Yep.
That gets done right here.
Nope.
All right,
It'll go to Ms. Feely and she'll get it to you.
All right.
Okay. Mr. Nukem, I'm going to follow the joint recommendation. I'm sentencing you on count 1, misdemeanor theft by receiving a golf cart, to 12 months to serve. Count 2, possession of drug-related objects, to 12 months to serve. I'm running those concurrently. That means at the same time. And you'll get credit for the time you've been in. You've been in for more than 12 months. So that's why you ought to get out tomorrow morning before you get breakfast, okay?
Yes, sir. Yes, sir. Yes, sir.
Any questions?
Yeah. I have a friend that he works in the county jail, and he told me y'all's new sheriffs, y'all broder bar deals, like y'all sheriffs could help me get on my feet working with the police, doing something called a confidential informant or a CI.
So couple things. One, law enforcement does work with CIs, but
I
that
don't
would
really
be.
know what it is too much, but they said they helped me get on my feet if I
Yeah, that
got
won't
to
be
jail.
through the sheriff directly, but just you may want to talk with someone about that. Maybe even at Gateway, you could talk with someone about that.
Yes,
Okay.
sir.
All right.
Yes, sir.
Ms. Clark, thank you for your time on this one. Thank you, Ms. Feely. Yes. So we're going to take a quick break for all of us, in particular our court reporter who's been taking all this down. That was a particularly interactive plea. But before we take the break, and this is not on the record, so Ms. Sims, you can start your break. What are we doing with Mr. Sabri?
Please, Judge.
To the misdemeanor offer?
Yeah, well, it's changed a little bit, but it'll.
Okay, to something.
Yes.
And then Mr. Howell,
Plea,
plea, and Mr. Isaiah.
also a plea, Judge, and his sister is helping him facilitate the Zoom, and she needs to get back.
Let's do Mr. Isaiah first. So right after the break, we're gonna take a quick break and then we'll do Mr. Isaiah. And that will free up his sister's phone. And then we'll go back to the order of the calendar. So it'll be Sabri and Howell, okay?
Thank you, Judge.
I think I'm done for the day, maybe.
Yes, ma'am. We'll see you tomorrow afternoon. And Mr. Abate dropped something off. I don't know if that's for you or for Ms. Clark. Are you gonna make it through the afternoon?
I'll be fine as long as I can sit down.
You can
I think it's my, just my blood sugar.
Yes, you can sit down, and I don't know what you should have a snack if you need a snack. Go for it.
Oh, my certifieds for, thank you, my walls.
Okay, great. You got them this time. All right. So I'll be back in about 5 minutes, and we will do Isaiah, then Sabri, then Howell.
Oh, where do I go? Did you already e-file it? Okay, so then you take this, if you go down to one, and then you go elevators, buy security. Interest file. Okay, so criminal docket or something. Excellent. Yes, and they'll be so happy. That just text me. Okay, perfect. I've been so frustrated with that because I think they should have tried to get something else, right? Hilarious.
Eat your food. Eat your food. I'm a cook.
You got some too, Chris?
No, I'm just.
Okay.
Seems like you too, Brownie.
Thank you.
Good. How the hell we do it? We can wait. We can do it.
What's your name? What's your name?
Oh, no.
Have you know 8 to 13 address?
Yes, ma'am. Judge McBurney called the James George matter. So that case is gonna, is actually going to be on, Thursday, at 10:45.
Oh.
Yes, ma'am, because I think Judge McBurney needed a second case for the, for his, I think, community outreach organization is coming, so he wanted a second.
Okay.
Yes, ma'am.
That's what it said.
Yeah, I don't think he, I don't remember seeing you on that because the defense attorney just messaged back, like late, not late, but yesterday evening, confirming for the judge that he would be able to do it. Yes, ma'am.
Counselor, yourself? Good. Sure. Ms. Clark, did you get something too? Are you okay?
I'm good.
We're gonna make it.
Just needed to, that peppermint helped me.
Okay.
Yes, sir.
Well, thanks to Ms. Willingham, another 27 pounds of who knows what. Ooh, there's a Jolly Rancher in there. That's.
Than a Twizzler.
There's a blue one. If I find a green one, those are my favorite though. It's funny you say that. The sour apple.
I love those.
Best. And when I was a kid, they weren't just these little puny things. They were these sticks. The Jolly Rancher stick. I've got watermelon or grape if you want one of those. Watermelon it is. There you go. All right, so you have Mr. Isaiah's case, so we can do that? Great. Oh, you've got everything left. That's right. Feely busted out of here. Okay, Mr. Isaiah, if you can go live, I will add you to the spotlight and we will remove the spotlight here and get Ms. Oh, she just disappeared. How'd that happen? There we go. Add the spotlight. There's Ms. Wood. And one more. There's our prosecutor. Ooh, and the handsome judge in the background. All right. Are you ready to go, Mr. Isaiah? Can you hear us?
Yes, sir.
Great. Is that your sister sitting next to you?
Yes, sir.
All right. Thank you for letting him borrow your phone.
No problem. Yeah, my screen had cracked on my phone. I'm waiting until I get paid Friday to get me a new one.
What do?
I prep.
Prep like like a chef?
Prep at Red Lobster.
Okay. Super. Well, we'll learn more about that in a minute. All right, we'll go on the record. This is position 15, 23 SC 188154. State versus, you pronounce it Davin?
Yes, sir.
Davin Isaiah, who is appearing remotely. His lawyer, Ms. Wood, is here in court, and the prosecutor, Ms. Clark, is also here in court. Mr. Isaiah, before we get started with the discussion about your plea, I need you to make clear on the record that you are waiving your right to be here in court. You have a right to be here in court, but you can waive that and appear remotely. Is that your decision?
Yes.
Okay, you also have the right to have Ms. Wood, your lawyer, sitting right next to you so that you could confer with her just by leaning over and asking your question or sharing something with her. But of course, she's here in court and you are appearing virtually. Are you waiving your right to have Ms. Wood by your side?
Yes.
Okay. Do know this, if you need to talk with Ms. Wood privately, just tell me and I'll have her step outside. She can call you on your sister's phone or your phone. You guys can have a private conversation. I don't think you'll need that given how this is going, but if you need to have a private conversation with Ms. Wood, just tell me and we'll make it happen, okay?
Yes, sir.
All right. With that, Ms. Clark, when you're ready.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You can put your hand down. Please state and spell your correct legal name.
Avin, Isaiah, Isaiah.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
We didn't hear your answer.
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
27, 28.
What's the highest level of education or the last grade you completed?
11.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offense? 1 count of possession of firearm by convicted felon.
That's not what I got here.
Wrong case.
Oh, my apologies. So sorry. This is Miss.
That would be a big surprise.
Oh. My apologies, Mr. Isaiah.
Yes, ma'am.
Wrong person. Okay. Do you understand you've been charged with the following offenses? The state will reduce burglary in the first degree to criminal trespass under 16-721. And the state will reduce theft by taking felony to theft by taking misdemeanor under 16-8-2.
Yes.
Is that your understanding?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had an opportunity to review the indictment with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Attorney Wood, do you waive a formal reading of the indictment?
So waived.
Do you waive any defects in the indictment for purposes of this plea?
We do.
Hello.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Okay. The state will provide those. For a criminal trespass, the minimum is 1 day in jail, the max is 12 months in jail, or it could be probation. And then for theft by taking misdemeanor, the minimum is 1 day in jail, the max could be 12 months in jail or probation.
Yes, ma'am.
Do you understand that today you're entering what is called a negotiated plea of guilty, which means that the state and defense
will recommend jointly for a plea of guilty. For count 1, criminal trespass, the state's recommendation is 12 months confinement, commuted to time served for count 1. And for count 2, theft by taking misdemeanor, the state's recommendation is 12 months probation consecutive to the confinement time, drug and mental health eval, and any recommended treatment. Is that your understanding?
Yes, ma'am, I understand.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole?
No, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes.
Are you in South Carolina right now?
Yes, sir.
Huh. All right.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 23 SC 188154, how do you plead to count 1, criminal trespass?
Guilty.
As to count 2, theft by taking misdemeanor, how do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
At this time, the state can provide a factual basis for the misdemeanor plea in this case, unless the defense will stipulate to a factual basis.
We'll stipulate.
So I have a couple questions. You don't have to dive deep into it, but I was just looking at the address where this supposedly happened. I want to make sure there's been either contact with the victim or victim has said, I don't care. I need info on the victim and just sort of how Mr. Isaiah ended up where this supposedly happened.
So the contact we've had with the victim, they really don't care what's done with the case. They just don't want the defendant to contact them.
Okay. Any sense of how Mr. Isaiah ended up at that address?
Your Honor, I think it might be, and I did forget this as a special condition. I had wanted mental health evaluation.
I got that.
Yeah.
Yep.
So, okay. So
if you don't, it's okay if you don't know. I just was, and Ms. Wood may know. I'm open.
Context, Judge.
yeah.
Okay.
The way,
I can just get it from her when she lays it all out. It just is a peculiar address for this to be happening. And it's a fancy car. I was just wondering how Mr. Isaiah came into contact with the Prabhus, Prabhu. Okay, so there's a stipulation that there is an adequate factual basis for this. Let me ask Ms. Jackson, is there any criminal history information for Mr. Isaiah?
He has 7 cycles. The last arrest was May the 10th, 2022 in Brookhaven, Georgia for burglary in the 2nd degree. There was no disposition for that arrest. He does have felony convictions. It's one in 2022 out of South Carolina for the breach of trust with fraud intended. One in 2020 out of South Carolina for assault and battery, felony in the 3rd degree. One misdemeanor conviction that was in 2019 out of South Carolina for possession of controlled substance. Nothing in addition, Your Honor.
Thank you. All right, Ms. Wood.
Thank you, Judge. There, at the time of this incident, there was some untreated mental health issues as well as some residential challenges. Now that he is back with his family in South Carolina, where all of his family lives, I've spoken to his sister. She says he's done a complete turnaround with his life. He is gainfully employed at Red Lobster. He seems to be doing
cook.
Yes, he seems to be doing very well there. He did serve 336 days for this, so that's another part of our negotiations.
And was that because he couldn't make bond? How did this come to pass? Just
Correct.
There was a bond set that was too high.
Yes, and our
Okay.
office was working with the bail project, trying to get it lowered. And so it's my understanding he has been with the family in South Carolina since that release. And so that's, you can, even just looking at him compared to his booking photo, he just looks so much better, Judge. So we would just ask that you accept the state's recommendation in this case.
Okay, and there would be, okay, got it. Mr. Isaiah, how did you end up in the Atlanta area if you're from, I think it's Florence, South Carolina? If all your family is in Florence, how'd you end up in the Atlanta area?
I just like Atlanta. I like music and I like movies and stuff. I was like, that's what I was trying to do, but like venture off on that. But it was just a wrong decision, just making this being anxious. That's all. Should have just been better because I ain't like I didn't have no money or anything. Like I've been working and stuff. Like they picked me up from my job. This making careless mistakes and this learning from my mistakes and this like letting go. Hopefully now like my family see that that's what I like to do, and just always got iffy word to say about this like, that you can do. Like don't overlook something that somebody like to do just because they don't show you. Might can show somebody else. If that make any.
So how long have you been working at Red Lobster?
I work at Red Lobster now for the last few months. Ever since I came back from my dad, from my father's house, I had got me a job and I've been on the world. I've been on the ball since. Like this week, make like the second week that I only been working like a few days. I go back to work tomorrow at 5. And hopefully I get some more. Hopefully I'll start back working 6 days a week again.
Okay, well, that'd be great. Well, Mr. Isaiah, I find there's a factual basis for your plea and that your plea is knowing and voluntary. Voluntary means no one's forced you to do this, and knowing means you've understood the things we've talked about. Do you agree with that?
Yes, sir.
Okay, then I'll accept your plea. Is it okay, Mr. Isaiah, if someone who works with me signs the indictment on your behalf indicating your plea of guilty to the 2 misdemeanors?
Yes, sir.
All right, and Ms. Wood, can we sign for you?
Yes, Judge.
And Ms. Clark?
Yes, Your Honor.
All right, on count 1, which is now criminal trespass, I'm going to sentence you to 10 months to serve. You'll get credit for the time you already served, which was 6 days more than 10 months. So you're not going back in custody. Count 2, which is misdemeanor theft by taking, making it the cheapest Land Rover ever. I'm sentencing you to 12 months of probation. That's misdemeanor probation, so you're not going to need to necessarily report in person. But I thought about just saying suspend the 12 months, but I think there are 3 important conditions that you need to comply with. Number 1, you need to figure out a way to get with a doctor or a counselor or someone to have a mental health evaluation. And if that doctor recommends any treatment, whether it's medicine or counseling, that treatment will be part of your probation.
Okay, and yes, sir. I have a question about that.
Yeah.
So, like, once the doctor says that, like, I don't need no medicine, like, can we stop like saying that type stuff? Like, that's kind of hurtful. Like when somebody like say you got a mental problem, and you really don't have a mental problem if you just step forward. Like,
So I hear you. It is a sensitive topic. I'm not saying you've got anything at all. I am saying that you want to be a productive citizen. You want to stay out of trouble, but you ended up many miles from home in a neighborhood that wasn't your neighborhood, and you ended up driving away someone's car. And that could have been because you're a bad guy, or it could have been because you weren't thinking about things real straightly. And what I'm being told is it's not that you're a bad guy, but maybe you weren't thinking about things in the best way to do. And so it is my direction. It's not a request, it's a direction that you do spend a little time with a doctor or someone just to make sure you're doing okay. That's all it is. And if you're doing fine, then there's no issue. So I'm not saying things are good, bad, or any other way. I just want to make sure someone checks it out. Okay?
Yes, sir.
All right. You also need to have a drug and alcohol abuse evaluation. And I am not saying that you abuse drugs or that you abuse alcohol. I don't know. I don't know you real well. I know that you are a prep cook at Red Lobster and you like movies and music in Atlanta and your sister's real good to you. That's all I know. And so maybe there's another issue in there that we need to make sure someone checks out. And if that issue happens to be there's a drug you use that you use too much of, then let's get some help for you for that. That's all that's about. Last thing is, while you're on this probation, you need to stay out of the city of Atlanta. So for whatever reason, if you need to come back to Georgia, you cannot be in the city of Atlanta for those 12 months that you're on probation. Okay?
Yes, sir.
All right. Ms. Clark, anything else on behalf of the state?
No.
Ms. Wood, will you be helping Mr. Isaiah with the misdemeanor probation reporting instructions?
Yes, Judge, absolutely.
Great. All right, Mr. Isaiah, you are done. You can give your phone back to your sister. Thank her for letting you stay on for so long. And I hope you get back to 6 days a week at Red Lobster.
Yes, sir. Thank you. I make sure I get the head on straight.
All right. Bye-bye.
Sir.
Mm-hmm.
All right. Let's do Mr. Sabri, please. And then last but not least, we've got Mr. Howell. You gonna make it, Mr. Howell?
Yes, sir.
Good. All right. Ms. Clark, let me know when you're ready.
Yes, sir. Just 1 second. I'm gonna make sure. Okay. Your Honor, on this plea, the state will be reducing the charge to disorderly conduct under 16-1139
All right.
from burglary in the first degree.
Okay. Got it. Mr. Sabri, you ready?
Yes, sir.
You've now watched a bunch of these, so you know how it works. You'll be put under oath and we'll take it from there.
All righty.
Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You can put your hand down. Please state and spell your correct legal name.
It's Abdullah Sabri, Abdullah, Sabri, Sabree.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you've not taken or been given today?
No, ma'am.
How old are you?
31.
What's the highest level of education or the last grade you completed?
Completed 12th grade and 2 semesters of college.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand you've been charged with the following offense? 1 count of disorderly conduct.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the indictment with your attorney?
Yes, ma'am.
And did you understand the indictment as explained to you by your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yes, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Attorney Wood, do you waive a formal reading of the indictment?
So waived.
Do you waive any defects in the indictment for purposes of this plea?
We do.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
The state will provide that information as well. For disorderly conduct, the minimum is 1 day in jail, the max is 12 months in jail, or it can be probation as well.
You understand that's the range we're talking about?
Yes, ma'am. Yes, sir.
Do you understand that you are entering a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For a plea of guilty for disorderly conduct, state's recommendation is 12 months probation, phone reporting, and waiver of probation fines and fees for 6 months. Is that your understanding?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand if you fail to follow all the special conditions of your probation, that you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
You understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 23 SC 187912, how do you plead to the charge of disorderly conduct?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am, it is.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
For a misdemeanor charge, you only have 12 months from today's date to file that petition.
Yes, ma'am.
As to the factual basis in this case, is the defense willing to stipulate to the factual basis since it is a misdemeanor plea?
Yes.
Nothing further from the state, Your Honor.
So I'll let Ms. Wood then, I'm gonna hear from Ms. Jackson in just a moment, but it's hard for me to massage this possible sentence in the way that I might want to when I don't know anything about the case. So that you guys are free to stipulate. That doesn't mean I'm not going to say, for example, how did Mr. Isaiah end up in that neighborhood? What was going on? Let me hear from Ms. Jackson first. And then Ms. Wood, I'm going to need you to just tell me a little bit about what was going on. And then Ms. Clark, if you think that that's crazy, that's not what happened, then you're free to add to it. Ms. Jackson, what do you have on Mr. Sabri, if anything?
He has 7 cycles. The last arrest was December the 28th, 2021 in Clayton County for driving without a valid license. He did receive first offender treatment in 2013 out of DeKalb County for aggravated assault and robbery. That case was sealed February the 5th, 2019. Nothing in addition, Your Honor.
Thank you. All right, Ms. Wood.
Thank you, Judge. I do want to start out, this case was dismissed at first appearance for lack of probable cause. And
First appearance?
Yes, by Judge Oliver.
Wow, I've never heard of something being dismissed at first appearance.
No, it's few and far between.
Okay.
And so that was last summer. And then, of course, this was indicted this summer. So you can imagine Mr. Sabri was very confused.
Surprised and disoriented.
Yes. Judge, without airing all of his business, because I know we are streaming today, he was in the wrong place at the wrong time, the wrong apartment. And he did not, instead of telling the actual apartment owner why he ended up on that balcony, he elected to say.
He made it all the way to the balcony, like in the door, all the way to the balcony, or?
Different balcony.
Okay, one balcony to another.
Yes, Judge.
Okay.
And so that is why the homeowner rightfully was terrified and thought, who is this person? And so that is how we are here.
Okay. Mr. Sabri, are you working these days?
Yes.
What do you do?
I'm an executive chef at Sweet Auburn Barbecue.
At who? A Sweet Auburn Barbecue.
Yes.
What does it mean to be executive chef? You're the boss chef?
Basically.
So you don't have to do anything and you make everyone else do stuff, but you get paid more?
Yes and no. I'll make sure the day-to-day operation is run, orders is fulfilled, and basically all my employees happy and satisfied.
Are you the owner of the business, or there's an owner and you're the sort of brains of the cooking part?
Yes.
The latter?
Yes.
How long have you been there?
Going on 4 years now.
Okay. This situation just ended. How do you end up on a random balcony?
Well, I was dealing with a young lady. At the time, I did not know she was married. So we were sitting on the balcony drinking.
And you needed to quickly leave that balcony?
Yeah.
Got it. Enough said. Okay. No one got shot?
Unfortunately, yes. I mean, no. Nobody
Okay.
got shot.
No one got shot. Good. All right. And that's when you learned that she was married?
Yes. He came in the door and started yelling.
Yeah.
I got dressed. And
you got out of there?
Yeah.
You got dressed. You weren't just drinking on the balcony if you had to get dressed.
Yeah.
All right. Fascinating. See, well, now I know when you guys stipulate that there's more to it. We've moved past that. Do you have any questions about the process we're going through today?
Not at the moment, no.
Okay. All right. Well, this would be the time. Like questions 2 days from now will be too late because we'll have gone in different directions. You're good?
Yes.
Okay. Well, now that I better understand the situation, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. Mr. Sabri, is it all right if someone on my team, my work team, signs the indictment on your behalf?
Yes.
Ms. Wood?
Yes, Judge.
And Ms. Clark?
Yes, Judge.
We will do that. Mr. Sabri, I'm going to do this. I'm going to sentence you to 6 months probation. I'm not going to make it, I'm not going to wait. Fees aren't huge, but it's only 6 months. And in terms of phone reporting, that's usually the default with misdemeanor probation. You're local, unlike the gentleman who was in South Carolina. So it may be they need to see you one time in person, but beyond that, given your lack of criminal history or relative lack of criminal history and the nature of this case, I'd be surprised if it is anything other than phone reporting. If you find that it is becoming onerous, let Ms. Wood know. She can reach out to me and I can see if we're going to modify it. But the way I'm choosing to modify it is to sentence you to 6 months of probation, but not waiving anything and not saying it's phone reporting. We'll just see how it flows. Okay? Any questions about that?
Nope, I'm cool with that.
All right. I didn't think you'd mind it. Ms. Clark, anything else from the state?
No, Your Honor.
Ms. Wood?
No, Judge, thank you.
And have you already connected with Ms. Nelson? Is this, he can go now and he'll report
Yes,
later?
I've already submitted his paperwork.
Got it. So you'll either hear from Ms. Wood or from misdemeanor probation, which is actually called Judicial Correction Services, JCS. I think it stands for Judicial Correction Services. Don't say, oh, that's spam, and not answer the call. They need to connect with you. And if they have trouble finding you, it's not because they have bad info, because Ms. Wood is giving them email, phone. And so if they send me a warrant saying we can't find this guy, that's just going to mess everything up. So just make sure, if you haven't heard from them, it's been a few weeks, call Ms. Wood to say what's happening. Okay? All right.
Absolutely.
Thank you. Thank you.
I'll send you the paperwork via email when it's filed, okay? All right, you're free to go. You're welcome. It was a pleasure. Mr. Howell. Judge, I knew you were gonna ask questions.
I picked up when you said, hey, we're streaming. I wasn't going to go too far, but like, I heard balcony, there's more to it than this. It's not that he's like, thought he was opening the wrong door and he's in the foyer. I'm like, wait, how do you end up on a balcony? He's like, well, I was on another balcony drinking with not a lot of couples. 1 second. Okay. Finally, Mr. Howell. This is our possession of firearm case. This is position 14, 23 SC 188131. Mr. Howell, you are all set to enter a plea?
Yes, sir.
All right. Well, you know what we're going to do. Ms. Clark will put you under oath in just a moment. Make sure you answer her questions truthfully and completely, and we'll go from there. Okay?
Yes, ma'am. Yes, sir.
Great.
Please raise your right hand.
There you go.
Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
You can put your hand down. Please state and spell your correct legal name.
My name is Brian Howell, Bryon. Howell, H-O-W-E-L. I got an initial, it's Clifford, C-L-I-F-T-O-N. Brian Clifford Howell.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
Yes, ma'am.
Tell me what is it you're taking?
What is it? Procedural back 3-4 Procedural Avenue.
What's the medicine that you're taking? What prescription are you taking right now?
RX.
What does it treat?
So tell me what the medicine is for. Why are you taking the medicine?
Yeah, I take it for my health and my health.
Okay, for your health. Does it help your health up in your head or in your heart?
I have a surgery in my head, and it vitamins. I take vitamins too.
Okay.
I go every 3 to 2 months.
Okay.
Check at grade.
Good.
Everything.
So the medicine that you take, do you take it in the morning or at night?
I take it in the morning and sometimes at night.
Did you take it this morning?
Yes, sir.
Good. And when you take that medicine, does it make you feel better or does it make you feel sleepy and woozy?
Stronger.
That must be the vitamins. Okay. Do you feel like you understand what's happening in here right now?
Yes, sir.
Great. Let's keep going.
How old are you?
50.
What's
50.
what's the highest level of education or the last grade you completed?
10.
Are you able to read, write, and understand the English language?
Yes, sir. Yes, ma'am.
Do you understand that you've been charged with the following offense? Possession of firearm by convicted felon.
Yes, sir. Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand if you plead not guilty or remain silent, then state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the indictment with your attorney?
We went over that in the hallway.
We went out the hallway.
So yes.
Yes.
And did you understand the indictment as explained to you by your attorney?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charge in your indictment against you, including the facts and circumstances related to these charges?
Yes, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Do you waive, Attorney Wood, do you waive a formal reading of the indictment?
We do.
Do you waive any defects in the indictment for purposes of this plea?
So waived.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
For the count of possession of firearm by convicted felon under 131B, the minimum is 1 year in jail. The max is 10 years in jail.
Yes, ma'am.
You understand that you're entering what is called a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court.
Yes, sir, ma'am.
Hold on one sec. What are you doing, Mr. Howell?
Oh, I'm getting my license.
We'll talk about it.
Yeah, you hold on and make sure you're listening to Ms. Clark.
Yeah.
For a negotiated plea of guilty, the state's recommendation is 3 years probation, with a mental health evaluation, treatment if required, and a behavioral incentive date set for 18 months. The defendant with the plea agrees to forfeit the weapon that was confiscated at the time of arrest.
Okay.
Is that your understanding?
Yeah, I understand. Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes, ma'am.
Are you currently on probation or parole?
No probation, no parole.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
I've been there, but I did it. And I ain't had no problem with it.
Okay, but you'll be on probation again. You understand that you gotta, once again, you'll need to do the right thing with probation.
Yes, sir.
Great.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses?
No.
No, we're not. So she's making sure that you understand that by entering a plea, we're not arguing mental defense.
Right.
You understand that? So say yes.
Yeah. Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Mm-hmm. Yes, ma'am.
As to indictment number 23 SC 188131, how do you plead to the charge of possession of firearm by convicted felon?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Myself.
So yes.
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes, ma'am.
At this time, the state will provide a factual basis for the plea in this case. One moment, Your Honor. If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on February 25th, 2023, officers from APD were conducting a direct patrol around Hank Aaron Drive Southeast and Little Saint Southeast due to the recent increase in car break-ins. While on patrol, Officer Smith witnessed a silver Ford Taurus equipped with Georgia tag TGU 3155 traveling northbound on Hank Aaron Drive, with the driver later identified as the defendant, Mr. Howell, operating his motor vehicle with his cell phone in his right hand. Officers conducted a traffic stop on the vehicle at the intersection of Hank Aaron Drive and Georgia Avenue Southeast. As they made a contact with the driver, the defendant, officers advised him of the reason for the traffic stop. Defendant Howell advised officers that he was just looking at his phone in his hand for directions to while he was traveling. Officers then requested that defendant Howell provide a driver's license, which he then presented with his identification card. He presented identification card instead of a driver's license. Officers returned to their patrol and car and processed his information through ACIC and later discovered that defendant Howell's driver's license had been suspended. Officers returned to Mr. Howell and informed him that his driver's license was suspended at that moment. Officer Smith then proceeded to place him into police custody. As the officer searched him due to the incident of lawful arrest for driving while license suspended, officers recovered a black Diamondback 38 Special from the left side of his wristband. As Officer Smith placed Mr. Howell in the back of his patrol vehicle, he engaged in a brief conversation and was informed by Mr. Howell that he had been arrested and convicted of a felony in the past. On 4/4/2015, he was arrested for aggravated assault and was found guilty and convicted of that charge on 10/12/2015 in Fulton County Superior Court. Mr. Howell was charged with, under OCGA 45-121, driving while license suspended, OCGA 1611-106, possession of firearm during commission of a felony, and possession of firearm by convicted felon. The gun was transported to Atlanta Public Safety and submitted as evidence, and Mr. Howell was transported to Fulton County Jail.
Got it. Thank you. Give me 1 second. Ms. Wood, well, let me hear from Ms. Jackson because then she can go. Ms. Jackson, criminal history, please, on Mr. Howell.
Yes, Your Honor. He has 21 cycles. The last arrest was May the 12th, 2015 out of Fulton County for serious injury by a vehicle and a DUI. There was no disposition for that arrest, but he does have prior felony convictions. It's one in 2015 out of Fayette County for possession of cocaine. And there was one in 2013 for Terroristic Threats Act, and one in 2005 for theft by receiving stolen property. And he has misdemeanor convictions. One in 2004 for driving while license suspended or revoked. One in 2002 for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you. Ms. Wood?
Thank you, Judge. Mr. Howell is a lifelong resident of the Atlanta area. As you heard, he has not been in trouble since 2015. I actually believe he might be on active probation. I don't see Miss Tucson. Oh,
She's on there.
Perfect. Out of Fulton for that 2015 case. We were just